But only before yesterday, your lordship heard the matter.
Yes.
And some instruction was sought for from the additional government advocate. Whether he is ready.
Yes. There was certain
Yes, ma'am.
confusion regarding this amendment
I'm giving-
and subsequent substitution of by other provision.
While I'm giving that notification by way of memo, your lordship has asked me that 1974 rule and the repeal. Well, before going to those documents, I'll draw my lord's notice only one date of his writ appeal. Your lordship may page 24, your lordship may see the date. Why I am saying that that are the relevance with those page 24 of the writ appeal.
Mhm.
Your lordship may see order 3/1/1992.
Yes, 92.
My lord, that is the date of his appointment. He is claiming. Then I have, your lordship may see the documents that 1974 rules on last occasion, your lordship has directed me to produce that rule, my lord.
190.
This is the old rule in the page 3.
Yes, my lord, that I have given the whole rule, thereafter repeal. Your lordship may see that whole. That honorable single judge has relied upon rule 5.
Yes.
And the your lordship can find it from rule 5. Your lordship may see rule 5.
Yes.
This is the jurisdiction of the managing committee, how whether the managing committee can give appointment in an already educational institution. Your lordship may see that rule 5 to 7, 1 to 7, only selection board is authorized to give appointment.
Yes.
Then your lordship may see rule 8.
The selection board is the recommending authority, and then on the basis of that,
management will give the appointment.
Yes.
Here, madam, your lordship has seen that on next page 24, selection board has not recommended.
Okay.
Management has given his appointment. And the only rule, sub rule 8, that gives the management to give appointment for a period of 6 months only with prior approval of the.
This is one aspect. When this school was brought under this grant in aid, when
Grant-
the school was brought, this Panchayat High School, when that was brought under the government.
Oh, that was the aided institution when that petition, when that appellant was appointed. But if it was taken over in 1994, it is in respect of this rule in respect of aided institutions.
Right, right. When this school become aided institution, do you have
That-
any?
Prior to 1992, he can say that.
I think 1990, Mr. Ratho,
Yes, yes, prior to my appointment.
prior to your appointment. There is no dispute about
There
this.
There
is
is
no
no
dispute.
dispute about it.
So you are bound by this rule, then rule 5.
Then- Why I have shown that rule, my date, my lord, why I have shown that date. The lordship last occasion has seen that rule 3 to 7 has been repealed. I have
4 to
unless-
7.
4 to 7.
4 to 7. I have, your lordship has seen then page 12.
That ground I am not taking because my appointment is prior to repeal.
That is the case. Your lordship has seen that Odisha Education Selection Board for the state rules 1992. There, your lordship see rule 15. Page 15, my lord. Your lordship can find it from page 15.
Yes.
The provisions contained in Rule 4, 4A, 5, 6, and 7 of the Odisha Education Recruitment Conditions pursuant to Rules 9 and the selection are hereby repealed. So that earlier rule
What
4,
is that provision you are reading? Yes.
your lordship has directed me to give that gazette notification. I have given that gazette notification next page. This rule that gazette notification at page 16,
Page
because
80.
that is not legible, so I gave that. Your Lordship can find it that gazette notification is
Oh, yes,
Page 16.
October 1, 1992.
yes, yes.
So why I am showing this date, my lord, that when he was appointed, that old rule was there.
All right.
And I have given that judgment, my lord. Your Lordship may see that Honorable Single Judge has relied upon that judgment. Your Lordship can find it. I have also given that copy,
Just give the judgment copy.
page 19. In that memo, I have given that.
All right. What the paragraph you are relying on the judgment?
Page 19, my lord.
Yeah, judgment starts at 19, which relevant paragraph?
Your Lordship can find it from para 12 to 14. It starts at page 25.
Yes. This is the same transaction.
And another judgment I have relied upon, even if that Honorable Single Judge has not relied upon, that the latest judgment of the Honorable Apex Court relying the same provision. Rule, Your Lordship, I have annexed that judgment also. Your Lordship can find it.
27.
Yes. Page 27. And Your Lordship can find that relevant portion, my lord, page, paragraph 26, page 32.
Page 27.
It starts from page 27. Well, relevant paragraph is para 26, page 32. My.
Yes.
That issue regarding prior approval. This is also that 74 rules and in respect of Hindi teachers.
Yes. They have quoted the entire rule. And what is the decision of the court?
Sorry.
What is the decision of the court?
Page para 27, Your Lordship.
Ah.
Page 34.
So whether this rule or the other rule, neither is helpful.
Para 32 is the finding. So, my
Mr. Roth, have you gone through this judgment? Have you gone through this
Well,
judgment?
I have not gone through. Your lordship may call it tomorrow.
Because it is very, para 32, they have decided the law
Yes, I
very
have seen. I have
concretely.
seen. I will have to
That may
see
be
whether.
very fatal for your case. That is why.
Yes.
All right, tomorrow. Heard Mr. M.K. Kuntial on it. Additional government advocate appearing for the state opposite parties. Mr. Kuntial and council has submitted a memorandum containing the various rules and the decision that the state intends to rely on. The said memorandum is taken on record. At the request of Mr.
I may pardon, my lord, those memorandum may be returned to us so that I will sign that. This has not been signed.
All right, all right.
And this has
They
not
could
been
sign
signed, I will
keep on the
sign it.
record.
my lord.
All right. At the request of
I'm just signing.
Mr. H.P. Ratho and counsel appearing for the petition, let the matter be listed tomorrow as part heard for continuation of hearing.
Okay.
Call the next item.
Item 2. May I please, Your Lordship?
Yes. Yes.
My lord, the respondent number 1, along with some of its members, claiming to be Petroleum Dealers Association of Odisha, filed a writ petition with a grievance that, my lord, the IOCL holds auction with regard to carrying the petroleum products to different petrol pumps. It is done in 2 ways. One is by the dealers themselves who have vehicle. Then whatever is left out, the present appellants and some other private carriers, they take it by way of also, my lord, auction, and they carry out.
Yes.
Now, my lord, there was a dispute amongst those Petroleum Dealers Association member and the private carriers like the present appellants. Now, there was a meeting before the sub-collector. At page 62, there was a settlement. Now, the writ petition is filed saying that the settlement has not been carried out, and we have filed a reply saying we are present, they are not present for the purpose of carrying out the settlement. Now, this becomes a disputed question of fact, and whether in a 226 jurisdiction this can be adjudicated or not, that is one aspect. The second most, which is important aspect, is they
Today is the first day, Mr. Mishra, that we have to issue notice because so many private individuals are involved in it.
My lord, the one aspect I beg to point out is we also question vis-a-vis the relief sought for in the writ petition. This is not maintainable in the present form because they only challenge police inaction, not the decision taken by the sub-collector. So it should have been a CRLMP, not a WPC. And if it is a CRLMP, it goes to some other honorable bench in view of the assignment made by Honorable Chief Justice.
All
Not
right,
for the-
that is a technicalities, but the question of maintainability of the writ petition will decide.
My
All right. Heard Mr. S.K. Mistral and its senior counsel. Assisted by, what is your good name?
Miss Sonali Panigrahi.
She is not on record.
Well, Mr. Saugat Das was there. I think just now.
Assisted
Yes,
by
he is there.
Mr. Sogota Das and counsel. For the appellant by means of this intercourt appeal. The order dated. It is 21/4.
My lord, because of
21/4,
defects, it came up many occasions, Superior Lordship. It could not come for fresh admission.
In WPC 677 of 2020, it is 2023. 2023 by the London Single Judge. The mainstay of the challenge is that the fundamental is the disputes between the several petroleum dealers. Even though this some policy election has been challenged in the writ petition. And as such, according to Mr. Mishra, the jurisdiction of this court under Article 226 ought not to have been extended for adjudication of such dispute of that nature. Admit to be heard on merit. Issue notice since MS S. Patnaik
For OP number 11, 12, 13,
Ah.
14.
Appears in notice for the respondents number 11, 12 and 13. No formal notice in respect of those respondents called for. Stop. The appellant shall take steps to service of notice on the remaining respondents by registered post with AD within 3 days. Within 2 days from today. Notice is made returnable on 14 September 2023. So, is there a necessity?
And there is a need of stay for the reason. I'll just point out
Ah.
one more thing for your lordship, to assist your lordship. They paid for the association. Now the court has extended to the carriers, no relief was sought for that. Now, out of 47 dealers who had grievance, 37, including the petition number 7 in the writ petition, had no grievance because they were participating. Only 9 persons, my lord, in respect of rest 9 persons. Now a direction has been issued which is creating chaos there, and there is lot of disturbance, my lord. The police is in play. Your lordship will see the annexures, and the sub-collector is there, collector is there. So therefore, your lordship kindly stay it, my lord.
2020.
My lord, the order is very, it's a generalist order, my lord.
But it is
doesn't
creating lot of
specifically- it
havoc,
says-
my lord, there.
It
Your
says
lordship.
that all valid carriers should have a peaceful transportation.
Yes, that is what you have to notice. That is
Yes.
why I'm asking you whether interim order is required, not at all. He
I'm
says it
praying
is
for
required.
my lord interim order because of this, but your lordship will see. If I show your lordship
All
only
right,
two
I'm
one,
asking an interim order, wait.
my
This just heard Mr. Mishra, huh? Medicine Council Estate by such and such, and also MS Patnaik, London, Additional Government Advocate appearing for the opposite parties number such and such. There's a application for staying the operation of the order dated 21/4/2023, delivered in WPC number 677 of 2023, under Annexure 3 to the writ petition. Step. According to Mr. Mishra, for the interim order, for the order, the impugned order, there's a serious chaos in carriage of the petroleum products. Stop. Which is stop. Miss S. Patnaik Land Council, London Additional Government Advocate appearing for the opposite parties number such and such has submitted that the direction is passed by the London Single Judge, in general nature, and such direction is not supposed to invite any chaos, be that as it may. In the interim, we direct that the opposite party number 5 shall decide regarding the transportation of the petroleum product. So the vehicle is the carrier is concerned. So this arrangement will continue till the next date. Let the matter be listed on the same date. So any chaos, you just approach this Indian Oil Corporation. They will decide. That is there, and their decision will be final for the time being.
IOCL and sub-collector, that is because they are coordinating.
Sub-collector, we cannot bring in sub-collector. He has no business with dealing with all these matters. You go
My
to the
sub-collector has
opposite party.
taken a decision, your lordship.
In presence of sub-collector, decision has been taken. He's a mere arbitrator. So we don't involve in the commercial
That's
transaction.
15, man, that's 15,
You
not
just
15.
approach this opposite party number 5. His decision for the time being will be final.
OP number 15, I think.
15.
5 is a private party.
15 is IOCL.
Just see in the 5 is not the Indian Oil Corporation. Just let us check.
Respondent number 15.
Okay, that's in the writ petition.
In the writ petition, your lordship, writ petition, it is 5. Here it is respondent number 15.
All right, instead of 5, make it 15. Respondent number opposite party number 15. All right.
And may I also,
The steps for service on the remaining respondents, accept the respondents number, opposite parties, sorry, not opposite parties, accept the opposite parties number, such and such, 3. Then the issue notice and such and such steps be taken by registered post with AD within 3 days from today. In the interim, such and such. All right. Any
Obliged.
difficulty, go to them, otherwise we'll decide on merit.
Madam, as your lordship, please.
Your lordship is fixing a date for this.
14th September.
Item 3.
Yes.
May I please, your lordship?
It's a series of petition.
These are the panchayat matters your lordship had heard the other day. So my lord had asked me to take what sort of interim order could be passed, whether their financial power would be seized and given it to Gram Panchayat extension officer. The two sarpanches are involved and one ward member. Ward member has no financial power as such. Sarpanches have some sort of financial power.
Yes, Mr. Mudali.
In fact, I have received the instructions that my lord may kindly see section 26(3) of the Gram Panchayat Act.
Get the Gram Panchayat Act.
My case is a case, your lordship, where no opportunity has been granted to me.
Compilation Act is maybe there. Twenty-six.
Yes, section 26 speaks of procedure of giving effect to disqualifications. In subsection 2, the collector may suo motu or on receipt of an application under subsection 1 make such inquiry as he considers necessary, and after giving the person whose disqualification is in question an opportunity of being heard, determine whether or not such person is or has become disqualified and make an order in their behalf, which shall be final and conclusive. Subsection 3, where the collector decides that the sarpanch, naib sarpanch, or any other member is or has become disqualified, such decision shall be forthwith published by him on his notice board, and with effect from the date of such publication, the sarpanch, naib sarpanch, or such other member, as the case may be, shall be deemed to have vacated the office until the date of such publication. He shall be entitled to act as if he was not disqualified. So it's a deeming provision that once the notification is issued under section 26(3), so he is deemed to have been vacated the office. And accordingly, after passing of the order on 3rd of July 2023, the notification has been issued. So as per section 26(3), he is deemed to have vacated the office. I am passing on the notification copy.
Mr. Sarangi, just you show me which order you have challenged.
I am challenging your lordship annexure 3.
Come to the annexure 3, read the order.
Page 20. Prior to that, I will take your lordship to page 19. I asked for cross-examining the witnesses, which was not granted to me. That is what I am challenging. I did not get any opportunity of defending myself. Your lordship may kindly look at page 19 in the first case.
No, order which you are challenging in this.
Order is at page 20, your lordship. And the operating portion. In the.
This is a passed by the authority.
That is that, your lordship, judgment, page 20, annexure 3.
This is passed by the collector.
Collector.
The collector under section 26 is the
challenged in the division bench.
My lord?
No, it was challenged for the honorable
Single judge, my lord.
I am asking you to show the.
Oh, my lord, single judge order. My lord, single judge order is at your lordship.
Whether this is a final order, this is
No, not a final order.
that
Interim
is
order not granted. That is why I am before your lordship.
all right.
That is at page 29.
Is it the interim order you are telling us?
Yes, your lordship.
Yes.
Page 29.
Show that where is this interim order was not granted.
I had filed an application, interim application.
No, you
your
show us that application was dismissed. Otherwise, it will be deemed to have been pending before the learned single judge.
Let me place it this way, your lordship. In next item, my lord, 1685, your lordship.
No, first come the first one that we have taken up, Mr. Sarangi. The
Yeah.
fact to fact, we have to check the, what is the.
Yes, your
position.
lordship. 1684, Parvati. That is there 21571, my lord. Briefs are there before my lords.
No, we have taken up WA 1684 of
Yes,
2020.
WPC 21571. It arises out of WPC 21571.
Ha, right. You just show us that there was any rejection or
There
you
is
have
no order.
moved there, learned council. Where are you coming to? Where are you?
There is no order, your lords.
That is where you are
the
embarrassed.
second
You are
case-
challenging a writ appeal and there is no order of the learned single judge.
In the first and third case, there is no order of the single judge. But in the second case, if your lordship would look,
Already second case will differ.
there is a interim order.
These cases where you have challenged this kind of an order, which is those numbers of the writ appeals.
I couldn't hear.
No, there are a series of writ appeals.
Three writ appeals. Three.
Three.
Your lordship may look at the second one, 21575.
The WA, there is no order rejecting your prayer.
First petition, no rejection order. But in the second appeal,
And third?
third also no order.
No order. Okay.
First and third, one category.
All right. Now you come to the second one.
My lord.
All right. Let us see.
Page 43. My lords finds it.
Yes.
Notice issued and all that. Then I number such and such. Looking at the averments in the I and considering the submission by the learned counsel of the petitioner, this court directs any development involving the issue involved herein taken place in the meantime shall remain subject to result of the petition.
All right.
So that order is there, but in those two cases, maybe honorable judge has somehow missed it or.
And you have missed it. You have not read the order, you filed the appeal, not the honorable judge.
No, I have said, my lord, no interim order has been passed. I have said in those cases.
But if the no interim order is passed, you have to show us that you pressed that application before the learned single judge. He did not pass any order.
That is my submission, your lordship.
No, see, your submission will not be believed by the court unless the records are produced before.
Record is there, my lord. In the
No, records there no, learned single judge has not taken up the matter. Record shows there was no occasion to take up that matter. The two applications that you have filed seeking interim
Let
order.
me put it this way, my lord. The writ petition was filed along with the interim application.
All right.
It was listed along with the interim application.
If you do not press, what will happen?
I did, your lordship. Anyway, that is something I can't say. That is not
Go
a
back
record.
to, we are asking you to press before learned single judge, and this matter will take up.
And that your lordship background can't be liberty
Yes.
for the first and third matter.
Yes. Now what is your submission here?
My lord, it is a case, your lordship, where my lord would see the order was passed on 3/7/2023, though the arguments were closed, though the order was dated 29/3/2023, but in fact it was signed and published on 3/7/2023. That is at page 25 of the writ appeal. Now, I do not know what notification my learned friend referred to. He did not serve me a copy. Anyway, my lord, this is a case where I am questioning, did not get an opportunity of presenting my case. There, this portion will your lordship will get at page 19.
19.
19. My lords comes.
Yes.
It is order dated 23/3/2013. 23. Case record taken up today. The petitioner and opposite parties are present along with their respective advocates. During this course of hearing, advocate for the OP filed a petition praying therein to call BDO, medical officer and Anganwadi worker for their cross-examination and allow time as their senior advocate has undergone eye operation. On the other hand, the advocate for the petitioner vehemently opposed the same on the ground that on earlier occasion, that is 8/12/2022, when these witnesses have come to this court, along with the relevant records in their possession with the readiness to be cross-examined, the OP opted not to cross-examine for no palpable reason. The present prayer by the OP to recall them for cross-examination is only with a view to lingering the process of inquiry. The OP chooses to contest the case without filing so-called reply. Heard both the sides, and this court is of the opinion that the petition moved with the counsel for the OP is devoid of force, hence rejected. Argument of the case is concluded today from both sides. Case is reserved for final order. Now, reference is made to the order dated 8/12/2022. There, I will take your lordship to that particular order.
How it is a denial of opportunity, that's also you did.
Page 16.
Page?
16, your lordship. It is handwritten, my lord. 8/12/2022. My lord finds it.
Yes.
Case record taken up today. Notice is present before the court. Notice is present before the court. Advocate for the OP is present and filed a time petition for time. The medical officer, CHC Khariar Road and Anganwadi worker present. They have produced their birth and death certificate registered and survey registered before the court. Peruse the date of birth of such and such. The OP has not filed her so-called till date. Time petition of OP is allowed for last chance. Put up this record on 12/1/2023 for final hearing. So, my lord, question of cross-examining these witnesses, and in fact, they were not put up for also on the dock, doesn't arise.
But in the final order, something has been recorded.
Final order says elaborately deals with that. I did not choose to contest the case.
No,
Well-
not the contest, the case that the witnesses have produced. You categorically denied to cross-examine the witnesses.
There is no examination at all. They produce certain documents, they say, but question of survey register before the court, perused.
Huh.
The date of birth of 3 children are as follows.
Huh.
That is all the finding is, my lord. And then the learned collector gives me time to file my so-cause.
No, what is your purpose? First of all, the witnesses they produced. You declined to cross-examine them.
No, it's not like that. I have to file a
You read the
so-cause.
final order again, the categorical finding is there. You
But
yourself
that
right now-
relates back to my lord, this
Yeah.
order, 8/12 order.
Huh.
The final order relates back to order dated 8/12/2022.
Yes.
On perusal of this, if your lordship would find or would
Huh.
reach to a conclusion, this yes, opportunity was granted to me, and that I had filed in my objection, that I can't.
Not a question of objection. According to the final order, you read the final order again. Relevant part.
Paragraph 3, my lord, at
Yes.
page 20. In order to prove its case, the petitioner has examined Anganwadi worker such and such. The information dated 2/3/22 by RTI Act has been marked as Exhibit 1 series without objection. And when these were exhibited also, we do not know. Because that your lordship would find that no indication is there on 8/12/2022 about such exhibits. Then, my lord, basing upon the above information, Miss case number such and such was registered. The petitioner has challenged the election of the opposite party for the post of Sarpach such and such under Nuapada block. That candidate of such elected candidate is based on corrupt practice, as he has suppressed to the factum of numbers of children, and accordingly his selection to the above post be declared void, as because such opposite party is disqualified under 25(1)(b) of the Orissa Gram Panchayat
You
Act.
only read the paragraph 9 of the judgment.
Paragraph 9. The OP was issued notice to appear on 8/9, but she did not appear before the court on 8/9/22. Thereafter, court sat on 15/9, 27/10, 8/12, 21/1/23, and 23/3/23. But the OP failed to file any so-cause reply. Further, on dated 23/3/2023, during the course of hearing, advocate for the OP filed a petition praying therein to recall BDO, medical officer, and Anganwadi worker for their cross-examination, allow time for, as their senior advocate had undergone eye operation. On the other hand, the advocate for the petitioner vehemently opposed the same on the ground that the earlier occasion on dated such and such, when these witnesses came to the court along with the relevant records in their possession with the readiness to be cross-examined, the OP opted not to cross-examine for no palpable reason.
So this is your stand that you opted not to cross-examine them.
But record by itself shows
No,
that I was not given an opportunity. On 23/3, I said,
No,
my lord,
that on 8/12.
8/12, my lord, admittedly also they produced certain records. That is the finding. They gave evidence in any way that is not there in this. And in fact, there is no evidence on record also that he will certify, he will verify. Normally, witnesses, depositions, all those things, those are not there.
Where is your notification that you shown? First to section 26(3). Right.
Yes.
ମୋତେ ଗୋଟେ କପି ଦିଅ କାହିଁକି সেম জিনিস ମୁଁ ଯୋଉ ଅର୍ଡର ସିଟଟା ଦେଇଛି ସେଟା ଦେଇଟା
notification ଟା ପରା left side ରେ
ହଁ notification.
second page ଟା office order.
When the notification was published,
In this case on 4/7/2023. Second page of this instruction, office order number 1021, letter 4/7/2020.
yes, Mr. Sarangi, what is your submission? 26(3) is a statutory provision. Right.
Right,
Says
like-
that from the date of disqualification till the that notification, he may be deemed to is in the office, but immediately notification is published, he has to be deemed to have vacated the office. That is the mandate of law. Whether any interim order can be passed stopping the operation of law.
In such events, either your lordship passes orders regarding till election is held or election may not be held. If your lordship prima facie finds that there is some weight in my submission that I was not given an opportunity. But speaking strictly about law, your lordship, the provision is very clear that doesn't take away notification. My lord, it's like this.
Three. When the collector decides.
Where the collector decides that the sarpanch, naib sarpanch, such and such has become disqualified, such decision shall be forthwith published by him on his notice board, and with effect from date of such publication, the sarpanch, naib sarpanch, or others member, as the case may be, shall be deemed to have vacated office. Until date such publication, he shall be entitled to it.
So it's very categorical provision.
Now, my lord, yes, your lordship, that is there. But the question here is,
I don't think, Mr. Sarangi, anything to interfere with, because otherwise we will be dealing with is stop the operation of law. That cannot be the purpose of this. And you have also not challenged this law also.
no, my simple challenge is not granting interim order.
That's what interim order.
26(3), I have not questioned it.
No, this is what you are now challenging on the basis of the merit of the case. So where the interim order is concerned, you do not contest the fact that you have been disqualified.
That is the
Ah,
order, my lord. How can I challenge?
All right, exactly. And the law started operating. Now on the basis of the result, if they found that entire basis was wrong, we will request the learned single just to expedite the hearing of your matter.
That is there. That is order is there.
All
Lordship may in any case observe that.
All right. So if you take the first two cases first. This WA 1684 of 2023, and the third in the same batch, the third case, such and such. Heard Mr. S. S. Sarangi, London Senior Counsel, assisted by Mr. A. K. Naik, London Counsel, for the appellants. Also heard Mr. M. Kuntiya, London Senior Government. You're appearing for all the opposite parties, I think.
There is a private party.
Appearing for the
Except
opposite
respondent
parties
number
number
5.
1, 2, 3, and 4. Stop. On scrutiny, we find that learned single judge has not dealt with the interlocutory application seeking the interim order. Stop. Even there is no trace in the record that the said application was pressed by the applicant writ petitioner for passing any order. Though Mr. Sarangi, Learned Senior Counsel, has submitted that such attempt was taken. But since nothing is borne in the record, we are not inclined to entertain these writ appeals, with liberty granted to the appellants to press such application before the learned single judge, if they are so inclined to stop. In the result, both the appeals are dismissed. Stop. And then the other second item, WA 1685 of 2023. Heard Mr. S. S. Sarangi and Senior Counsel such and such, and also such and such. by means of this intercourt appeal, the order dated 14/7/2023 passed in IA number 10263 of 2023 arising from WPC number 21575 of 2013. 23 has been challenged by the said order. When a single judge has observed inter alia as follows. Quote, this code directs, it is a continuous sentence, start with the ellipsis, dot. The code directs any development involving the issue involved wherein taken place in the meantime shall remain subject to the result of the writ petition. Mr. Sarangi Learned Council has submitted that the order is specific interim order allowing the writ petitioner in the interagnum to act as the member of the panchayat.
Yes, my lord.
Member of the panchayat, even to the Mr. Sarangi has submitted to that extent that their financial power may not be with them during that period. Stop. Per contra, Mr. Kuntia Learned Council has drawn our attention to the provisions of section 26 of the Orissa Gram Panchayat Act 1964. Stop. Subsection 3 of section 26 of the said act unambiguously provides as follows. Code 3, where the collector decides that the sarpanch, naib sarpanch, or any other member is or has become disqualified, such decision shall be forthwith published by him on his notice board and with effect from the date of such publication, the sarpanch, naib sarpanch, or such other members as the case may be, shall be deemed to have vacated office, and till the date of such publication, he shall be entitled to act as if she was not qualified. So Mr. Kuntia Learned Council has produced before that by the office order number 1016. What is that? Mr. Muduli, I'm sorry. Just not Kuntia, Mr. P.K. Muduli, Council for the State. This is a 4/7/2023 notification.
Yes.
You don't have a copy?
Yes, I have. 4/7/2023.
By the order dated 4/7/2023, the district panchayat officer, the competent authority, has notified the disqualification. According to Mr. Muduli, additional government advocate, in view of the provisions of subsection 3 of section 26 of the Gram Panchayat Act, the appellant has to be deemed to have vacated his office. Stop. Having regard to the said provision, we are of the view that by any interim order, the court cannot stop operation of the law when the particular law has not been challenged before it. Stop. As such, we do not find any merit in the writ appeal, and according the same is dismissed. However, before parting with the records, we would request to learn a single judge to hear the writ petition expeditiously, so the objections raised in the writ petition by the appellant be taken care of and adjudicated finally. No orders to cost. Next.
Item 4.
May I read your lordships? This is the public entry litigation. The opposite party number 7 is a college and 8 is its authority. They have enclosed 5 feet in their college building and 10 feet requires thereafter.
4.
4 is my item.
4. You are wrong, learned counsel. Just check up your cause list. 4 is a someone's matter. Your matter perhaps is the next item. Gandharva Senapati Balakrishna. That is your matter, I think. Gandharva Senapati versus State of Orissa. It's the item, next item. Wait for some time.
Sorry,
Yes.
May I please, Your Lordship? In this appeal matter, the order passed by the Honorable Single Judge dated 14/7/2023 is under challenge matter at Annexure 1. In this case matter, sole point is to be adjudicated is that whether my appointment was valid or not, matter. I was appointed as an Anganwadi worker, matter, and the advertisement was published on 25/11/2016, matter, wherein the last date of receipt of application was fixed to 9/12/2016. And I have, my lord, applied as per the advertisement, I have submitted all my relevant documents along with residence certificate on 9/12/2016, my lord. That is not disputed. But dispute is that my challenge was made, allegation was made with regard to my residence certificate, my lord. But I have obtained the certificate before the last date of application, my lord. And the Honorable Single Judge hold that as there is a stipulation in the advertisement that the residence certificate was to be obtained before 6 months of before 6 months. The clause was within 6 months before the advertisement was published. That was a stipulation. But I obtained the certificate after the advertisement. So whether that is valid or not, this is the sole point, my lord.
How it can be valid when there's certain advertisements?
But I am coming to that,
yes.
madam.
Come to
But
that.
as per miscellaneous certificate rules 1984, the validity of the residence certificate.
Forget don't bring the foreign things when this notice says certain things to be done by certain ways. How those rules be relevant?
No, rules, that was no fixed date appointed in the rules, my lord. This before such date certificates to be obtained, my lord.
You have not challenged the advertisement.
No, my lord. I am coming to that point.
Yes.
But this is the sole point is that when the last date of application, my application was also valid. But the OP number 5, my lord, whom I have made the opposite party, her application was invalid as per the validity of the residence certificate. And further, my lord, there was a stipulation regarding
read your certificate, Mr. Raiguru.
Yes, ma'am.
You read the certificate that you produced with your application. Annex that certificate.
Yes, ma'am. In the read petition, ma'am.
Just read from the read petition.
Yes.
Text of the certificate.
Yes, ma'am. At page 14 of the read petition,
Yes.
here's annexed. This is to certify that Srimati Kunni Behera, wife of Sri Dipti Ranjan Behera, is a native of district of Nayagarh in the state of Orissa, and she or her family ordinarily reside in the village town Kumarpada PS, Khandapada, Tahsil, Khandapada in the district of Nayagarh. This certificate is being granted only for the purpose of service. Thereafter, note, it is digitally signed or generated certificate, therefore needs
No, forget about this, the certification. Tell me where this advertisement requires to show you that the preceding, from the date of publication of the advertisement, during the preceding 6 months, you are the resident of that area of this Anganwadi center.
Yes.
Whether even the certificate gives this kind of a declaration? No.
No, my lord.
So how can you claim on the basis of this certificate that you are a permanent resident during the last 6 months of that time? You come to the now advertisement.
Yes, my lord. My advertisement clause 2, my lord. Is the ODI, my lord? Yes.
Whether this WPC record is there?
Yes, my lord.
No. Find out that record. Yes. It's all right. Got it.
ପ୍ରାର୍ଥିନୀ ସମ୍ପୃକ୍ତ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଅଞ୍ଚଳ ସ୍ଥାୟୀ ବାସିନ୍ଦା ବୋଲି ସମ୍ପୃକ୍ତ ତହସିଲଦାରଙ୍କ ଠାରୁ ପ୍ରାପ୍ତ ହାଲ ସ୍ଥାୟୀ ପ୍ରମାଣପତ୍ର
No, where is that clause? Where it is?
clause 2
Clause 2. Just read the clause.
ସ୍ଥାୟୀ ବାସିନ୍ଦା ହୋଇଥିବେ।
Hal means correct. Hal स्थायी बासिंदा प्रमाण पत्र स्थायी बासिंदा प्रमाण पत्र विज्ञापन तारीख पूर्व 6 मास मध्य प्राप्त होइथिबा आवश्यक दाखल करिवे। पूर्व 6 मास मध्य।
Yes, madam. Madam, if that
Who is appearing? Yes, Kunti, you are appearing. What does it mean?
What that?
No, just can it be a valid clause for any service?
No, it's not. That must be residential certificate.
Clearly that they can demand that you show that at least 6 months you are residing that area. But it says the certificate has to be obtained within the preceding 6 months.
Yes, ma'am.
How someone will know that advertisement will made is?
Yes.
I'm just admitting this petition.
People have obtained the certificate within the preceding 6 months.
What does it mean? Suppose the advertisement is published, now the certain documents is required. How someone will know that this will be published and I have to require this certificate?
yes,
Either they must have obtained the certificate or advertisement time and
That's a heard Mr. B.S. Rai Guru on it.
last date they should have been, not advertisement date.
Council appearing
That has
for
been
the-
wrongly mentioned.
This actually is the wrong wording.
That wrongly worded. He must have it
Yes,
should be
right,
written. He
and
must
council
have a
appearing for
valid
the
residential
appellant.
certificate, not on the date of advertisement.
Within the last date.
Yes.
So that is how will he know that?
Yes, on the last date of the cut-off date filing the application. That should have
By
been done.
means of this intercourt appeal, the appellant has challenged the order dated 14/7/2023, passed in WPC number 11995 of 2020, with a single judge. Mr. Rai Guru and council has submitted that.
Only people who know it will be
They-
advertised. will
Despite the appellant filed the required certificate,
Literally.
but on the ground that the certificate was not obtained within 6 months preceding the date of advertisement, her candidature was not accepted, and opposite party respondent number 5 has been engaged as the Anganwadi worker.
no, my lord, I am
No,
continuing.
in fact, he was appointed. He was
I
enrolled.
was
Right. Oh, sorry, it was stopped. No, sorry. On the ground, just this certificate, his candidature, that part, huh? His candidature is a later on declared invalid in as much as the certificate was not obtained within preceding 6 months.
Where is your residential certificate?
Madam, I have shown that
Preceding
at
6
the
months
Next year?
annexed,
from
my
the
lord,
date of publication of
Let
the
us see.
annexed, my lord,
stop. It has been stated
Uh,
that Mr. Rai
for-
Guru,
4, my lord,
on the
page
basis
14 of the
this
repetition,
selection,
which was
the
I was
petitioner-
reading.
the appellant has been engaged as the Anganwadi worker, and she is still continuing,
Yes, my lord, since 2/5/2018, my lord,
and she is continuing in that position since
2/5/2018.
2/5/2018. Stop. Later on, the opposite party, the respondent number 5 has been engaged in his place, but by virtue of the interim order passed by a single judge,
No, madam, there was no interim order.
then how you are allowed to continue?
Not even.
Madam, what happened? He has filed appeal. Appeal was dismissed. In the meantime, I was appointed. I was selected candidate, madam. But the opposite party came before the Honorable Court by filing writ petition, challenging the order of the appellate authority.
All right, the respondent number 5 challenged the candidature, the score out that na later on, of the appellant, and by the order dated such and such. That where is that order?
Madam,
Single bench judge's order?
Annexed 1, madam. At page, madam.
No. This is the order.
Yes, ma'am.
By the order, by the impugned order,
19, page 9.
the candidature, just type it out. Candidature of the appellant was set aside. Hence, this appeal, admit this appeal to be heard on merit. Issue notice since Mr. Kuntia, Council, M.K. Kuntia Lanet, additional government advocate, appears in web's notice for respondents number 1 to 4. No formal notice is called for in respect of those respondents. Stop. The appellant shall take steps for service of notice on the opposite party number 5. Now, I number 4676/2023, heard such and such on the prayer of staying the operation of the judge order dated 14/7/2023, passed in WBC number such and such under annexure 1 to the memorandum of appeal. Stop. Also heard Mr. Kuntia, learned additional government advocate, who is appearing for the opposite parties number 1 to 4. Stop. Issue notice. Notice is made returnable on same day of 14. Earlier case was 14/9. 14/9. No, earlier also notice is returnable 14/9. Sentences. The petition, the applicant will take steps for service of notice on the opposite party number 5. They registered close to 80 within 3 days from today. Meanwhile, the operation of the impugned order dated 14/7/2023 shall remain suspended.
I shall not disengage.
Stay, hello.
Stay, you want stay? I vacate the order. I pass the stay order then.
Okay, no.
Item 5.
From Puri BC, may I plead your lordships?
Yes.
This is a public litigation. The opposite party number 7 is a college. The opposite party number 8 is college authority. They, while
Who are you?
I am appearing for the public petitioners matter.
Yes.
They have enclosed the public road. They constructed their building on their own land, but a part of a building is encroaching 5 feet and their boundary encroaching 10 feet another. They have encroached their eastern side public road of 30 feet. They have encroached to 15 feet. My lord, from the lower level authority, revenue inspector to collector, we moved and filed representation, sent postal notices. No action was taken. Thereafter,
It is a government college.
It's
no, my lord, the private college, just
private college, Puri Women's College.
I think it's
That is a government college.
It's a
No, this is not the government
from
college.
Vadodara.
It is not a government college.
No, just aided, my lord, it was a private college.
Aided
My lord, your
college.
lordship may see annexure 5 at page 32 of the writ petition.
Huh.
For the self-same issue, on the self-same allegation, a civil suit is pending before the competent civil court.
By the same person?
No, not by the same person, but he has relied upon that plain copy.
Yes,
Filed by
my lord. His front door college, the front door neighbor Due to his problem, he has filed a suit. But no action, not any injunction order has not been passed. The status order, nothing has
For
been.
that, you are not entitled to come to public interest litigation. Basically, it is a land dispute.
That is what I beg to submit.
And who filed the suit?
That is neighbor of the.
That is the front door neighbor. Front door neighbor.
Front door neighbor regarding government land, what suit I can't understand.
No, the neighbor of the college, she filed the suit, he filed the suit that there is an encroachment, so mandatory injunction to remove a permanent injunction not to make any construction. That is pending before
That
this.
must be
civil court.
regarding their land or both are encroaching.
No, they are saying that it is government land and they are encroaching, that plaint. So at best, if the petitioner is also interested to contest this claim, he can participate in this suit by making an intervention application there.
No, not necessarily, because if that civil suit has been filed by somebody which ultimately nothing will come out of it, why should he be asked to intervene in that?
That is only
Yes.
my respectful submission that the same
Okay.
issue is now sub judice in a civil court at the instance of a party who is not before your lordship in this petition.
I may be permitted to speak.
Yes.
My lord, he constructed his building since 19. Since 21, he has come. Permanently obstructed the public road. Since 21, the people, thousands of people, public people are suffering, my lord.
Learned counsel,
Cannot go in
you
that
come
line.
to your annexus 6.
Yes, my lord.
You come to your annexus 6.
Fairly he
Yes,
has
ma'am.
given.
Yes, my lord. That is 133.
For what purpose 133 proceeding is there? For just removing the obstruction of the government land? And
Yes,
road.
my lord.
So why the necessity of the public interest litigation? We rather
My lord,
direct this SDM, what is it called in Orissa?
Subdivisional magistrate.
Sub-collector is the authority.
So,
on Section 130.
Sub-collector is the authority.
Why don't you
Yes.
follow up that proceeding?
My lord, before filing sub-collector threatened us. I have pleaded specifically, my lord.
No. We are passing a direction over the sub-collector to decide the matter within 6 weeks from today.
Yes.
Yes, my lord. Oblige, my
That's all.
lord.
That will,
Oblige, my
Yes.
lord.
because
That-
otherwise it will be a parallel proceeding.
My lord, kindly allow 1 minute, my lord. Before
Yes.
receiving the 133 application, sub-collector threatened us not to file against the college.
No, you are protected by the High Court.
I have pleaded, my lord. I have pleaded.
You are protected by the High Court. High Court is taking cognizance of this proceeding as. No, this
Response of the sub-collector.
Sub-collector may be directed, my lord.
All right.
Yes, ma'am. Yes.
Why threatening someone?
No, that's-
My lord, he did not receive, my lord. Entire administration is supporting, my lord.
I don't know.
Kind
but,
of a conduct of a public servant.
but,
My lord,
whether
all
this-
Wrongly goes to him. Someone even wrongly goes to him.
because these are all judicial proceedings. A sub-collector is a quasi-judicial authority so far as 133 is concerned. Why
No,
he'll threaten
Because,
me? I don't
because the
understand.
suit, I think, when 133 proceeding is done, it is the fundamental duty of this sub-collector to remove the illegal construction.
Yes, my lord.
Yes, ma'am. He must have engaged lawyer and that is a proceeding and question of threatening the person concerned, I think.
No, but he has stated that paragraph
yes,
8.
that
that immediately after presentation, the
Yes.
petitioners were threatened.
I have seen that.
But Mr. Who are you? Mr. Rai, are you
Yes,
the
ma'am.
petitioner in that 133 proceeding?
Some
Your wife probably.
some of the petitioners,
Yes, my
Okay,
lord.
okay.
common petitioners.
All right,
Yeah.
all right.
Third,
I have
Mr.
attended that forum. I learned from.
Balakrishna Roy,
All right.
learned counsel, appearing for the virtual High Court from Puri location. Stop. This is a public interest litigation seeking intervention of this court by way of a direction to remove the obstruction created over a public road by way of an unauthorized construction / encroachment by the opposite parties number 7 and 8. Stop. Mr. Royal and Council has submitted that since the opposite party number 7 and 8 have encroached and constructed a boundary wall by encroaching the road earmarked for the public road, there is a general resentment in the public of that locality. One of the neighbors also filed a civil suit in the court of the Civil Judge Junior Division, Puri, being civil suit number 04 of 2021, seeking
Permanent.
permanent injunction against these said opposite parties, within bracket defendant in the suit. Stop. According to Mr. Rai, nothing has happened in that suit. And the suit between a private individual and the opposite party numbers 7 and 8 herein. Stop. Even though the restraint order, interim restraint order has been passed by the said court, but the opposite parties number 7 and 8 are not
Have violated the.
obeying the said order. Violation. Stop. But it has been stated that the violation case, but this case for violating the said order has not been filed as yet by this, has been filed also by the plaintiff of the said suit. Stop. Mr. Royal and Council has drawn our attention to a proceeding initiated by one Srimati Lakshmi Priya Pradhan and Haraprasad Tripathi under section 133 of the Code of Criminal Procedure 1973, urging the subdivisional magistrate Puri for removing the said illegal obstruction and the nuisance created on the public road. It may be noted here that those petitioners in the proceeding under section 133 of the Code of Criminal Procedure 1973, being criminal miscase number. What is the miscase number?
Number is not there.
29 of 2023. Are the petitioners numbers 7 and 8 in this petition. Stop. According to the petitioner, the opposite party numbers 7 and 8. The petitioners have described the disputed land petitioner has filed the documents relating to the disputed land as annexure 3 series. Stop. Yes, we are not going to pass any decision on the merit of the dispute in view of the pendency of the miscase number 29 of 2023 under section 133 of the CRPC. We would direct the STM Puri to complete the said proceeding within a period of 6 weeks from the date when he would receive a copy of this order
It's
from
on the date of
petitioner.
service of the order.
Petitioners, after affording the reasonable opportunities to the parties, including the petitioners and the others who might be affected by any order of the STJM in the said proceeding.
STJM.
We make it absolutely clear, the petitioner will be at liberty to take appropriate action at law if they are aggrieved for any reason by the order of the STM that is contemplated to be passed by the STM within the said time. In terms of above, this petition stands disposed of. Next.
Item 6. My lord, this petition is relating to the filling up of vacancy of member in the Odisha Human Rights Commission.
My lord, I have filed the letter from the law department, that the instruction from the law department, and lordship may kindly see.
They are going to appoint.
No, in inviting a reference to a letter so and so, on the subject, I am directed to say that the matter of appointment of member of the office of OHRC Bhubaneswar is under active consideration of the government. Hence, the honorable court be appraised accordingly.
We are granting you 2 months' time. You are granting you 2 months' time.
2 months' time.
Fill up the vacancy.
Obliged.
3 months, within 2
No,
months,
no,
we will
my lord,
have.
It
My
is
lord, I am
a
unhappy
simple
because-
matter of notification.
Yes,
There's
yes.
a lot of
Okay.
eligible and competent.
Then your lordship may finalize this case.
Just finalize
My
it.
lord, in DK Basu case, in 2015, the Supreme Court laid down that any vacancy arises should be filled up as expeditiously as possible,
That is the
but not
problem.
later than 3
That is
months.
what my
That
lord-
is the problem. That is what you understand by expedition. The bureaucrats understand differently. Their expedition is 2 years, and we are talking about the 2 months.
Yes, my lord.
So
Even
that
in
is
the
where you are
last docket of
specifying the
this
time, Mr. Das. Just wait. Mr. Prabir Kumar Das,
Yes, ma'am.
the petitioner in person. Stop. By means of this public interest litigation, the petitioner has asked this court for directing the state of Orissa
Party number 2, my lord.
and the Principal Secretary, Law Department, Government of Orissa. The opposite parties number 1 and 2 respectively, for appointing the members of the Orissa Human Rights Commission, which is lying vacant for a considerable time. And the state opposite parties, as mentioned before, are not taking any action towards filling up of those vacancies. As a result, the Orissa Human Rights Commission is functioning without being a full-fledged commission. Stop. In response to this allegation, Mr. D.K. Mohanty, Learned Additional Government Advocate, has produced before us a written instruction he received from the Law Department on 31/7/2023. It has been stated in the said written instruction by the Undersecretary to the Government of Orissa Law Department that the state government has been actively considering the appointment of the members of the appointment of the member against the existing vacancy in the of the Orissa Human Rights Commission. Stop. Having considered the rival submissions, we are constrained to observe that this should not be the stand of the state government when a statutory commission is having vacancy. Stop. the vacancy has to be filled up as expeditiously as possible in order to make the Human Rights Commission function with its full strength. Stop. Having regard to this observation made by us, we direct the opposite parties number 1 and 2 to fill up the existing vacancy of member of the Orissa Human Rights Commission within a period of 2 months from today. Stop. A copy of this order be supplied to the council for the
Yes.
parties for transmission to the competent authorities without any delay. Stop. In view of the above, this petition stands allowed and disposed of. A copy of the written instruction is submitted before us is taken on record.
Item 7.
My lord, item number 7, this has become infructuous. No cause of action surprise because they have challenged that such one on-shop may not be opened. And that proposal for license for on-shop has already been rejected by the state.
So it's Mr. D.K.
Mr.
Mohanty, an additional government advocate, has placed before us a written instruction he has received on 2/8/2023. Stop. From a reading of this said written instruction, it appears that the question license of IMFL on shop has already been prayer for. No, this was a prayer. No, the proposal for proposal for granting license to open a IMFL on shop has already been cancelled by the state government by their order number 377/EX stop dated 29/5/2023 for violation of the provisions of the existing policy 23-24. You are Mr. Bishwajit Naik?
My name is A.K. Patra.
Mr. A.K. Patra, learned counsel, has readily agreed that has submitted that in view of the said decision taken by the government, this public interest litigation has become infructuous. Accordingly, this petition stands dismissed as infructuous. The written instruction dated 2/8/2023 is submitted before me is taken on record.
Grateful.
Next.
Item 8.
May I please your lordship? My lord, the petitioner's grievance is that the opposite parties have taken up a project under the Mahapokhari project
It is Mohapokari.
over the
That is not Mahapokari, that is Mohapokari.
over the Gochar land, over which
Even the
several
pond cannot be
trees-
excavated over the Gochar land?
That I have to take instruction.
Huh?
I have to take instruction.
All right. You are Mr. Roth.
My lord.
Heard Mr. M.K. Ratho, learned counsel appearing to the petitioner. There's a public interest litigation seeking directions from this court not to allow the Gochar land for excavation of a pond. Stop. On the face of such submission, Mr. D.K. Mohanty, an additional government advocate, has prayed for a short accommodation for taking instruction. The prayer stands allowed. Let the matter be listed on 28th of August 2023. Meanwhile, Mr. Mohanty, an additional government advocate, shall obtain a comprehensive.
I will file counter affidavit.
All right, Mr. Mohanty, stop. The opposite parties may also file a short affidavit.
Yes, ma'am.
Instead of instruction. Would it come on 28th of August? Let us see what is the government's stand. Yes.
Item 10.
Maybe, pardon, in the cost title, one mistake is there. The name of the village has been wrongly typed. Let me correct
it and put a signature below it.
My
Keep the record. Yes.
Item 10.
First correct the copy of Mr. Mohanty.
I will correct. Item 10, my lord. On behalf of Mr. V.K. Naik, my lord. Here, my lord, this is also a public interest litigation. Here, the opposite party numbers 4 to 7, they have
Just the earlier order, no? Mr. Roth, learned counsel appearing for the petitioner is permitted to correct the typographical mistake that is appearing in the cause title.
Right.
After correction, Mr. Roth shall put his signature below it as a matter of authentication. All right.
well, item 10, my lord. The opposite party numbers 4 to 8. They have also encroached the government land, my lord, situated over in village Katak Sahara, recorded in Khata number 146, plot number 103.
Opposite
In-
party number 4 to 8.
4 to 8. 8, 7 and 8 is a private limited company, my lord.
Yes.
He has constructed a boundary wall over the land of the village Katak Sahara, my lord. And
Heard Mr. M.K. Rathul and counsel who is appearing on instruction of Mr. B.K. Naik and counsel for the petitioner. So by means of this public interest litigation.
Have you submitted a representation? No.
yes, I have submitted. Villagers have submitted representation on Annex 7, my lord.
The petitioner has asked this court, to direct the removal of the illegal encroachment over the government land by the opposite parties number 4 to 8. Stop. On the face of such allegation, Mr. D.K. Mohanty, an additional government advocate, has asked for a short accommodation for taking instructions. Let the matter be listed on 28/8. In the meanwhile, such instruction shall be taken by Mr. Mohanty, an additional government advocate. Or alternatively, this state opposite parties, number 1 to 3, may file a short affidavit traversing the allegations made in the writ petition. All right, on the same date, your matter is this matter come together.
My lord. Obliged.
Item 11.
Item 11, Lordship, here is also public interest litigation. Issue of 2011, Lordship. In fact, Lordship, kindly see page 10.
It still survives according to you.
Lordship, in fact, Lordship, still there. Lordship, can see page 10. In fact, I had approached through a contempt petition and disposed of only on 6/3/2022, Lordship. On 10.
Page 10.
Lordship, kindly come to page 10, Lordship. Well, Lordship, I just am reading. It is seen from the so-called affidavit of the Commissioner on Annulment that he is not able to put the property in question to auction sale since the occupants of the property was unable to be evicted. He made request to Tahsildar Brahmagiri and Collector Puri after the order passed by the court on 4th March 2011 in writ petition such and such. But without the occupants being evicted, he was unable to proceed with the action. It is seen from the order that this court that the specific direction was issued by the commissioner not to proceed with the action of the property without evicting the occupants. To that extent, it cannot be therefore said that commission has disobeyed the order of this court. If needed, the problem is about the occupants continuing in the property in question. It will open to the petition to file a separate proceeding of for direction to Tahsildar Brahmagiri and Collector Puri to take effective steps in compliance with the order such and such. And let's now this writ application because still that another encouragement there. And if you let's you kindly see the order I have quoted, I have annexed as page running page 28, the operative part of the earlier writ application.
Is it a conduit public interest litigation, Mr. Dalu?
In fact, Lordship, it
is a conduit public interest litigation. You are strengthening the hand of the government to evict some person, maybe the poor person, do not have any shelter.
No, Lordship. This matter, Lordship, this property relates to a deity, Lordship, Lord Alarnath, Lordship. And earlier there was a auction process was settled by the endowment commissioner. Though the rate was available of 80 lakhs, but he settled the land of the 60 lakhs. That was the challenge before Lordship. And Lordship, while disposing the writ application, public litigation, a Lordship passed order on running page 28. Lordship kindly see come to page 28.
You have annexed that
If-
order.
Lordship, annexure 2, running page 28, Lordship. Internal page 8 and 9, Lordship, of the order itself.
Is 4/3/2011 order? 4/3/2011.
Lordship. Para 9 and 10, the 2 paragraphs sufficient, Lordship.
Yes.
Lordship, I'm starting from para 9, Lordship. The said regions are totally irrelevant, which cannot be allowed to sustain in the said regions, are not germane to issue which arose for consideration under section 19 pursuant to the direction issued in the earlier writ petition referred to supra. Therefore, the impugn order is liable to be quashed. For the reasons stated supra, there is no proper determination of the market value of the property as directed by this court in proceedings in relation to the public property of the aforesaid deity. Therefore, this is a case in which public interest is affected. Hence, the order dated 2/8 is liable to be quashed. Then, para 10, Lordship. The contention urged in the counter statement filed by the opposition 6 that the one Nrsingo Jena has filed a petition in writ petition number such and such, registered number such and such, to be implemented a party which was rejected by order such and such, and the writ petition was allowed by order number such and such, against which writ appeal was filed by the Nrsingo Jena challenging annexation such and such, Lordship. By order dismissed. The said writ appeal is totally irrelevant for the purpose of consideration of the correctness of the order imposed in the writ petition. Therefore, the writ petition must succeed and direction must be issued to the opposite partner too. Endowment Commissioner there, Lordship, for reconsideration of the matter for giving with wide publicity, inviting persons interested to participate and give the order of market value, the offer of market value in respect of the property. We should direct if offers to be received would fall short from the market value, the procedure may be deferred till the property fetches market value. Until the property fetches the market value, the same need not to be sold. For the reasons the writ petition is allowed, issue rule opposite party number 2 is directed to comply with the direction issued by in this order by taking necessary steps is possible. In fact, region being there are more than 500 acres of Lord Alannath. All the lands have been encroached by the unauthorized encroachers. This is the glaring example, and court has taken example of only 2 acres of land, Lordship, and it will go now more than 5 crores. It was settled earlier time with 60 lakhs, where the offer was available of 80 lakhs. That's why Lordship directed to go for action till that, Lordship.
But there is an order that until the market value is fetched, nothing will be done.
Lordship, no,
So
if
these
they-
encroachers will continue there till market value is
No, no,
fetched.
if the, no, it will, my record, my state, it will go to more than 5 crores now, Lordship. Today, if they will come for action.
Mr. Mohanty, this finding out the market value is a very simple process.
There is a benchmark valuation.
That is one thing. Even the simple process, any land acquisition collector, they know how to determine the market value.
Yes.
Let that be a reserve price. Market value may be the reserve price for the auction. And let the auction, because there is nothing to decide. Decision has been already taken by this
Yes,
court.
now auction is to be held by the endowment commissioner, not.
Ah.
So his grievance is that the encroachers should be evicted because the endowment commissioner is saying that without eviction of the encroachers, we cannot.
But
proceed.
this is not his prayer here, unfortunately. And after evict them to go for the auction. But this come to the prayer. This is not. He says only to take the prompt action to evict the parties number 3 to take prompt actions to evict the unauthorized encroacher from the deity's land as described in the order dated 4/3. So this is a limited purpose of eviction.
Eviction followed by auction, Lordship. If they they will be evicted because Lordship cancels the expansion of the endowment commissioner. He showed his inability because they are unauthorized encroachment. I could
No,
not.
Mr. Dolo, just tell us, how do you know about the right of the persons who are squatting over the land?
All are unauthorized, Lordship. They have no
You are
right.
saying they are all authorized, but that there should be some decision over that they are unauthorized.
Listen,
If the High Court passes an order, evict them. We do not know how the third party right has arose by this time.
No, Lordship. In fact, no third party right, Lordship. In fact, Lordship kindly see the cost title of the writ application, the page 17.
Yes.
Lordship kindly see.
And why the question of auction is coming if it is a deity's land?
That is, they are put to, they have settled the land in favor of personal lordship with a very less price, that is a 60 lakhs lordship. When the auction was available for 80 lakhs, they settled it in 60
I
lakhs.
understand, but why the question of auction is coming?
Now lordship, because court directed, because the land value was very high. So because it will go
That
to
is
the
a subsequent thing. The court has intervened regarding the rate. But who took the decision for auctioning a part of the land which stood in the name of the, or standing in the name of the deity?
lordship.
What is the necessity of auctioning the land?
In fact, lordship, only to avoid unauthorized encroachments, lordship. If it will be settled, then money can go to the, that is.
No, that is also a
perhaps
question, endowment commissioner, whether the permission of the endowment commissioner is still there for selling out this land.
in section, by using section 19 lordship, they can settle the land lordship, or they can go for
It
auction.
is a question of settlement.
Settlement by way of auction, lordship. Settlement by way of auction.
Whatever way, but ultimately it is a
Lordship.
settlement. They want to give the
Lordship.
land for some purpose.
And I think the persons in whose favor the settlement was earlier made, they were included as part.
No, that order has been quashed by this public litigation.
That order you've seen.
That order has already been quashed.
Quashed. So only they will go to for fresh action by evicting them, they'll go for fresh action, lordship.
Where you should ask also for going for the fresh action. Some order has been cancelled. They are already in a position to take a fresh decision also whether they will auction out the land or not.
Because court has given direction for auction, lordship.
And this in the first public interest litigation, eviction was not a subject matter.
No, lordship.
No.
You are bringing this is a new subject matter.
Now, because by disposing the writ application,
No, it has been observation that would be after evicting this person.
lordship,
But to evict a person from the land,
lordship.
there should be some proceeding should be followed.
They will follow, lordship. Lordship, I am not saying that without following the procedure, they will evict them. They should follow the procedure, but we would need to comply the lordship's direction, lordship.
Yes.
And lordship, just one development I have received just now, lordship. Lordship, can you see? For some time, my representation just now received, collector has already intimated to the tahsildars and other authorities, lordship, to proceed the matter. Only I had 2 copies that I supply.
Mr. Mohanty, have you checked up this?
No, I have not. I have no copy of that.
Just now received,
That is
just
not
now
attached.
received, lordship, that's why I have 2
Alright.
copy. Person my representation annexer 1, lordship. The collector has acted upon.
Give him a copy.
Lordship.
Then he'll get the complaints and this one.
Lordship.
This is a kind of a vague order the officials sometimes pass. Directing the whole does have the power to evict by proceeding someone from the government.
Tahsildar, lordship. Tahsildar can evict, lordship.
Tahsildar is the competent.
Competent, tahsildar they
All
can.
right.
But
So he closed the writ petition because of this.
let them may not act up. Lordship, let it be pending. Let them file a
No,
complaint.
we'll say that this has been done and the eviction process should be expedited.
Lordship.
And
Yes.
they
And-
shall not.
And to comply the lordship's direction, lordship.
In terms of this order.
Right. We are referring this.
Sounds a collector's order or High Court order?
High Court's order.
High Court order.
No, High Court order, collector has directed
No,
the
this is
Tahsildar
in
to
terms of
implement the High Court's
this
order.
is, Mr. Mohanty, it is in terms of a contempt matter.
Yes, ma'am.
There you assured that you will carry out, and that was the result. The contempt was dropped.
Yes, ma'am.
And now this says that you just do that and file the compliance affidavit before the High Court.
Yes.
That is relating to the contempt proceeding. The reference has been made there. Contempt case number 2348 of
Both applications have
2011.
been disposed.
Yes,
Both
that
applications
is
have been
CONT,
disposed
correct.
of. So we will pass the direction in
Yes,
this
yes.
only.
All right. Art Mr. S.K. Dalai Lanet Counsel appearing for the petitioner. This is a public interest litigation which have its checkered history in the earlier public litigation, which has a checkered history, as by filing an earlier public interest litigation being WPC number 9962 of 2011, the similar issue was raised. Stop. In that writ petition by the final order dated 4/3/2011, the in which paragraph is
Let's see if they are.
the
That's a contempt order. Let's see.
no petition when this auction has been
Way back 2011, let's see, the judgment that is.
by this final order dated, the order dated 2/8/2008, by which the auction was settled in respect of the land in question belonging to the deity Aleknath.
Alarnath, let's see.
Alarnath.
Alarnath, was quashed. Stop. It had been further directed that the endowment commissioner, opposite party number 3/2 was endowment commissioner.
That's
Two
two.
was an
Two.
Ah,
Of an
the endowment commissioner, within bracket the opposite party number 2 in the earlier writ petition being WPC number 9962 of 2011, was directed to reconsider the matter and give wide publicity, inviting the persons interested to get the settlement of the land as referred in the said order. On the prevailing, on terms of the prevailing, and settle the land on terms of the prevailing market value. Stop. It was also clearly observed that until the property fetches the market value, the same need not be sold. Stop. There was another writ petition thereafter.
There. Let's see. Annexure 1, let's see if I have filed. Person after this content disposal, I have
Stop.
filed.
After passing of the said order, dated
I had filed the content petition, let's see.
2012, when the endowment commissioner did not act in terms of the said order, a contempt proceeding
Let's
was initiated, being CONTC number 2348 of 2011. In that proceeding, where is the contempt case order?
Order, Lordship, page 10 I have quoted, Lordship, page 10.
Quoted in the writ.
Page 10 I have quoted, entire ordership, Lordship. Collect order.
It was held that the commissioner, the opposite party number 2 in the writ petition being WPC number 9962 of 2011, did not disobey the order of the court, as there were trespassers squatting over the land in question. Stop. Even in this petition, the petitioner has stated that the unauthorized encroachers, quote unquote, have constructed their permanent establishment and they are running the business by earning crores of rupees ignoring the interest of the deity. Thus, the petitioner has asked this court for directing the authority to evict those unauthorized encroacher from the land of the deity forthwith for purpose of the settlement of the land by way of auction. Mr. Doloi Learned Council has today produced before us a communication issued by the additional district judge Puri to the Tahsildar Brahmagiri referred to the order dated 4/3/2011 passed in WPC number 9962 of 2011 and the order dated 26/2020 passed in contempt CONTC number 2348 of 2011. Asking the Tahsildar for compliance of the orders of this honorable court by evicting the unauthorized encroachers from the deity land. Unquote. Stop. That we are directing, if the encroachers are gives the market value, they should be continue to their
Let's
position.
put that may not, because other buyers
Tell
will
me
come.
why not?
It may raise heavy lordship. In fact, lordship, now it will go to around 5 crores. If they will be there, definitely they will try to settle it a very low price.
All right.
Otherwise, temple will be not benefited, lordship.
No, it's all right. The Tahsildar shall comply the order of this court by way of doing up of the eviction proceeding for purpose of evicting the encroachers on the deity's land as referred in the order dated 4/3/2011 as mentioned above. Stop. The said eviction proceeding shall be completed as expeditiously as possible. Stop. But that should not, but by any rate, that shall be completed within 31st of January 2024.
Yes.
January.
January 2024, more than 5 months, I think.
Rainy season is there.
Because rainy and many people have to be noticed. They have to initiate a appeal.
31st of March.
March.
No,
31st
in
of-
fact, lordship, land was settled in front of renewable deo. In fact, she is in possession. She has given rent to others,
No,
lordship.
no, this is all right.
So,
There should
one
be a
person is.
proceedings. There should be
March.
31st of March.
How is it encroachment?
No,
No, because by his possession already passed by this honorable court, so definitely he is a trespasser now.
okay, this who given them on rent.
Rent, let's say. The owner, she has given,
They are the innocent people, that is why.
but it is a heart of the Brahmagiri.
This by 31st of March 2024. Stop. We would hasten to add that we have not decided any claim on the title over the land,
Lordship.
either by title or by your prescription.
Lordship. Grateful, lordship.
3 copies.
Free copies of this already supplied to the Learned Council for the parties forthwith.
Item 12.
Please, my lord. My lord.
12.
Hard.
22.
12.
Hmm.
My lord. My lord, here, the petitioner is also like,
12, I'll take a short, but let the matter
like
come. to
10
me.
years, my lord, he is in custody,
I-
basing on a
let-
circumstantial evidence.
let
There is
me
no
place
charge.
my-
There is,
Let me
Please
place
allow
my
her
predicament
what she
for
Yes,
intended
yes,
to
yes.
submit.
But the file was,
Don't stifle her voice. Allow her submit. Yes.
the file was assigned to me, my lord, but last night it could not come. Let it come tomorrow.
Yes, Mr. Panda will readily agree if it is taken up to.
I don't have any objection. Other day
No,
also my madam was
No,
arguing that matter.
I'm conscious. I've gone
I-
through it.
You
but
are
I just
arguing, you are arguing fully. No, last occasion.
All right, we have seen.
No, I don't have any
Completes the
objection.
Matter tomorrow at the
Tomorrow.
request of Ms. S. Patnaik, an additional government advocate appearing for the state. Mr. Niranjan Pandal, and counsel appears for the appellant who has filed this application seeking the bail from this court. All right,
Tomorrow, my lord.
tomorrow.
Oblige.
Item 13.
Yes, Mr. Lenka.
In your lordship, I prefer 1 week time.
1 week.
Mal.
It may come in the last part of the August again. This month only, August. Let the matter be listed on 28th of August, 2023 at the request of Mr. N. Lenka.
Mohanto, HK Mohanto.
H.K. Mohanto.
Mal.
And counsel with the appellant. Yes. S. Patnaik, additional government advocate has appeared for the stay. Yes.
Item 14.
Here I am for the appellant on behalf of UCO Bank, my lord. The order of the Honorable Single Judge has been stayed by your lordship since 2021. I am reading the hearing of the matter, but if you're on a prior date, my lord, Honorable Chief Justice had directed the legal aid to engage a lawyer of 10 years standing because the opposite party number 1, he was paralyzed. So when today nobody is there, in all fairness, my lord, in view of my lord Chief Justice's order, whether the lordship wants me to argue, I am ready. But last 2 dates,
You are appearing for the
I am appearing for the appellant, my lord.
appellant. So we need a representation for the opposite party.
Yes, your lord, Honorable Chief Justice has directed that this file be placed before the Legal Services Authority and lawyers with 10 years standing
Yes.
be appointed. But and a lawyer had appeared on the last date, my lord. But today it seems nobody is there. Your lordship wants I can place, but that order is there.
Someone was engaged
Pardon, my lord.
legally.
Yes, someone was engaged. He was appearing on 2 dates, but today is not there. Whether it,
Mr. R. Das Naik.
yeah. So that order is there of the Honorable Chief Justice, your lord.
Himanshu Bhushan Das was the last 17th May.
So the lordship wants to engage somebody else from the legal aid.
No, because we are sending information to Mr. Das and Mr. Das Naik to be at to please comment to. Huh? No, not to. They've taken up after this matter. I have to come at 3 p.m. Let other matters are there. You come at 3 p.m. Just if you can kindly just give me the information, Mr. Himanshu Bhushan Das and Mr. Das Naik.
I'll try my best to inform them.
Otherwise,
I'll be there at 3 p.m.
Okay, we are also in our channel. We are trying to contact them.
Yes,
If
because
you
that.
can somehow you meet them, you just ask.
Yes,
them to
if that.
come.
Yes,
We'll look into the matter.
yes, at 3 p.m.
At 3 p.m.
My lord.
Item 15.
I am appearing for the appellant.
Yes.
I prefer 1 week time to file the reply.
Here, my
The
lord, may I
affidavit
see-
filed by the respondent number 2.
My lord.
1 week
curious-
lordship time.
My lord, I'm sorry.
No, this, how they have filed the affidavit in this stage?
My lord.
Why the respondent number 2 has filed the affidavit?
My lord, this,
Your lordship-
in this case, though, this is a appeal.
Have you filed it?
My lord,
There is 2 appeal. One
Ah.
is 753. I am for the appellant.
Huh.
And in that case, that respondent number 2 has not even appeared because address was
my
not
lord, but
correct.
in the
That was
other
not-
case, I am appearing for respondent number 2. It's the
for
same
the-
respondent in the other case also. I have instruction to appear.
Then you appear. Then you appear
My
for
lord,
him. Then notice will be sufficient.
My lord, the notice will be treated as sufficient, my lord.
All right.
And my lord, in the other case, there is a stay order operating, my lord. Here, what has happened, the entire case is the order of the Human Rights Commission is under challenge.
We'll take up the matter for final disposal of 18th of August.
May I
17th August, sir.
18th
May I
of
pray
August.
one thing, my lord? The copy of the appeal memo may kindly be served to my lord and pray for the
My lord.
appearing for the respondent number 2A.
All right, 18th you come for the final hearing.
Pardon, yes, I am ready for final hearing, but
18th of
Appeal memo may kindly be served.
the second matter because
My lord,
Because
it
first
needs to be
matter.
served because
First matter,
now
my
that notice is sufficient, treated to be sufficient, my lord, because I am
because
appealing.
I
No,
mean,
no.
kindly be served means he will serve.
No, no,
I-
that recording, he was referring to.
Oh, acha, acha.
It appears that notice on limitation on the respondent number 2 returned unserved with the postal remark insufficient address. Mr. Haripad Mohanty, learned counsel, who is appearing in WA 950 of 2021.
361.
361.
360.
I am appearing in 361.
There is 950. Oh, you are-
Is it 15? In appearing the respondent number 2 in WA 361 of 2022. Stop. Mr. Mohanty, learned counsel, has submitted that he has instruction to appear also in this case. Stop. Stop. Hence, the service on the respondent number 2 stands complete. We would request Mr. Mishra, T.K. Mishra, learned counsel, to supply a copy of the memorandum of appeal with all enclosures. Stop.
My lord, copies of.
Mr. Mishra has served the copy of the memorandum of appeal to Mr. Mohanty in the proceeding. Stop. The matter will be listed on 18th August 2023 for disposal on merit. Delay can be condoned.
My lord, delay can be condoned because
Stop.
it be heard on merit. My lord, delay will come down.
Only in the first appeal. Second one, there is
Second
no
appeal, there
delay.
is no
Yes,
delay.
first.
There is no delay.
Lordship, interim order continue. Lordship.
Wait. Only 750.
In IA
19.
1918/2022. This is an application for condoning the delay in filing the intercourt appeal. The delay is of 61 days. But since there is no opposition against the prayer of condonation, we condone the said delay for enabling the applicant to carry out the appeal. So accordingly, this application stands allowed and disposed of. Just above that, just this appeal, they bring down this appeal order,
I got delayed.
that we admit the heart surgeons after that, no? Mr. T.K. Mishra, having regard to the controversy raised, having regard to the grounds of objection, we have the view that this appeal to be heard on merit and accordingly the same is admitted. Issue notice. Who is one?
Human Rights Commission.
Who is one? Who is appealing for the one?
Human Rights Commission, my lord.
Human Rights Commission.
You.
I can appear.
Order of the commission is being challenged.
My lord.
Yes.
Then not-
Who appeared for the one earlier occasion?
No.
Earlier occasion, my lord.
I am appearing for the.
Human Rights Commission.
No.
For the appellant in the second appeal.
Because they have served a copy on me, but whether I can. appear, because
Since
that is
the
a
order of the statutory commission
Commission order.
was challenged in the connected concerned writ petition, we do not find any representation for their behalf is required. However, they shall be at liberty to represent at the time of hearing. As such, we request Mr. D.K. Mohanty, learned additional government advocate,
Yes.
to kindly contact with them and take the instruction for the
Yes, ma'am.
Orissa Human Rights Commission to place their view before us on the next date.
Yes, ma'am.
So we are engaging you as a council
Yes,
virtually.
a
Yeah.
free copy of this.
I will give. Stop. The opposite part, the respondent number 2 is represented by Mr. H.P. Mohanty. Land Council, NSS service is complete. Then you go, let the matter be listed on 18th for such and such.
Along with WA.
Along with
36,
WA number such and such in WA on the same issue.
Well, same issue, same
That-
proceeding.
All right, then name the council.
Lordship,
is
interim order
appearing.
continue.
Wait.
Other. All right, it will come on that day, 18th.
Obliged.
And the second
Lordship,
case,
interim order
whereas
continue.
interim order is passed earlier shall continue till the next date.
And a free copy of the order.
A
maybe.
free copy of this order being
What is your name?
given. Be supplied
Girish
to
Chandra Sahu.
Mr. Mahanti, London Additional Government Advocate, for his use and transmitting the same to the Orissa Human Rights Commission.
Second case is appellant and it is GC Sahu.
Already 16.
Item 16.
16, my lord, may kindly permitted to withdraw.
Already, have you filed the memo?
My lord, I'll file ma'am.
You have filed.
No,
Yes.
my lord, I have not
Filed
filed.
it,
Yes,
okay.
my lord.
Let's see. You have already filed your memo, which is a mention memo. So,
That is the problem.
all right. You're Mr.
Yes,
Your
my
name?
lord.
Mr. Mishra.
Yes, you file a proper withdrawal memo.
Well.
That is only a mention memo.
Are you there on record?
This is transfer brief, my lord.
You have filed the Vakalat number.
Yes, my lord.
What is your good name?
Vishnu Prasad Rath.
Okay.
Okay, is there Ratho. Mr. BP Ratho, Learned Counsel, appearing for the appellant, has submitted that he has instructions to withdraw this appeal. In this regard, a memorandum seeking leave to withdraw has been filed.
My lord.
You filed in the course of the, otherwise you will not sign the order.
Right.
Stop. We do not find any impediment. Accordingly, this appeal stands dismissed as withdrawn. All right.
Right.
Anyone is appearing for the state in this matter? Mr. M.K. Khuntial, and additional government advocate, appears for the state respondent. All right. He has withdrawn it.
16.
Memo, give the
File.
memo.
Yes.
Is there.
You file it.
Is
Yes, my lord, course of the day.
Call.
Item 17.
Mr. C.R. Patnaik, yes.
Notice has gone, limitation ground notice has gone. Oh, yeah, has not written.
Not notice not issued. Notice not issued in
No.
limitation.
It has not written. It is.
Oh, sorry. Let us see.
But they can to remove all the defects.
If there is one defect still not removed. You just remove this 5B. It appears from the ministry's note that the notice issued on respondents number 1 to 4 notices have not returned as yet. Wait for the service reports. So as the service report is waited, let the matter be listed on 4th of September 2023. Registry shall upgrade the report confirming whether the notices are delivered to the respondents number 1 to 4 by the next date. Yes.
Item 18.
Item 18, my lord, there is a 71 days delay.
Huh.
And one. My learned senior has also appeared through caveat.
This matter is already covered by your lordship's order, judgment matter. Since it was not uploaded, my lord, I've got in the meantime, it has been uploaded and directly covered by this matter. Here the question was, my lord, though the powers were available with the J department being sent by the concerned authority, my lord, because it was not submitted to online, my case was not considered for DSP promotion. Your lordship already rendered the judgment, my lord. If you lordship.
Lordship, that is my lord's judgment. I am giving that copy. Only some distinctions are there. So otherwise, lordship, see my lord's judgment.
Now the question is fundamentally is that whether someone is unable for whatever reason, the SAS could not be uploaded.
No.
But SCS exists.
Yes, ma'am. That
Yes.
your lordship has held in that judgment.
Ah.
In this case, that is the distinction, what has happened.
Yes.
In fact, she has submitted PAR on 9/3/2022.
Yes.
Up from the year 2015 to 2021, he submitted it on 22/3/2022. That is the
Problem,
except
distinction.
that your lordship has, I have gone through my lord's judgment here. Your
Whether
lordship is,
this accepting authority or reviewing authority has put their
sorry,
comment on
I am not.
Oh, whether the accepting authorities or the reviewing authorities has put their comment on those SCS.
On 9/3.
9/3.
2022.
Some of the SCS are there. You give him the show cause notice, but you cannot say that I will not consider the SCS.
Yes, ma'am. That what I am submitting, your lordship has decided that issue. And in that judgment, your lordship has also dealt with that regarding that. In that case, they have submitted their PAR in time.
Yes.
But it could not be uploaded because of internet problem.
Yes.
But in this case, this is the admitted fact. He has submitted in late.
No. What is the prayer? Ultimately to consider the SCS.
Yes.
No. That on the basis, if you SCS is a 22 and you are claiming for consideration from a retrospective date, that court will not.
No, I'm not. I'm saying, madam, let my case be considered, madam. Let DSP scheme is available in 2019. I have submitted the documents, my lord. It was submitted by the concerned authority, my lord, in February 2022. And June, my lord, DSCP promotion DPC start, my lord. And they have said since it is not submitted online, I have taken the recourse.
Only the delay point that if the time was consideration was somehow crossed, then we understand. But if these are available, this is a simple method of a conduct of these, that you can proceed for this conduct. But when this the SCS comes into being, what do you say, the CCRs?
PAR.
But this then you are bound to take into consideration.
Yes, ma'am.
And just understand this. The important part of this SCS or the PAR, whatever.
Yes, ma'am.
That is what is written by the reporting officer, accepting officer, and review officer. And the first part of this form is a self-appraisal report. What I report about myself. So those parts are not for this because they only could not put their opinion because there was the first part was absent. The officer concerned did not submit that first part. So there was no question of accepting, reviewing, or
yes,
the other part.
Yes, ma'am.
So if in the meantime this DPC is over, we will not allow her to claim any benefit.
Yes.
But if the DPC is not over,
the DPC is over. Already DPC is over. I'm not. DPC was over on 11/10/2022.
11/10, and when those were filed in when the PARs were filed.
PARs are filed. It was transmitted on 15/3/2022. She submitted it on 9/3/2022.
Yes.
And the GA department received it on 25/3/2022.
Yes.
Not on offline. Only hard copies were submitted on not on online for the year 2015 to 2021.
All right.
So if your lordship will direct that, will consider his offline application. Except that I have seen, but
when the DPC was convened
on your lordship, that DPC was convened on 11/10/2022.
That is much after this receipt there.
Yes, ma'am. As it was why it was rejected, as it was submitted offline on 25.
That we have discussed.
That times it was rejected only on that ground. And in a bunch it has been submitted in late. If your lordship will direct that to consider it offline application, that
this consider it.
And
but you can also draw for this conduct of the petitioner.
Yes,
you can start this show cause.
That your lordship has observed that in that judgment paragraph.
If your lordship kindly go through the annexure 5 to the ETAP, they have submitted the GA department note sheet. They have taken, since it is not available through online, we have not considered. Only that is the ground.
That I am
And in
submitting.
respect of others, my lord, even the doctor who is working here, my lord, this.
No, just wait, that we understand, we are taking a
Yes.
very lenient view. But we understand when the government says this will be the only system, your PARs will be searched only in the system, not anywhere else, no other files. Because we have said the technology is, we are accepting here, so there will be initial snag and initial glitch. So some lenient approach should be taken. But this conduct is not, we are not appreciating that conduct.
No, your lordship is
Kind
correct,
of a
but it,
defiance to the administrative order.
my lord, it was never made mandatory.
Yes.
No, that was made. That was made, a certain relaxation for a category because of employees was earlier given.
Yes, it was mandatory, my lord,
Ah.
since 2000. Your lordship
Lord,
can find it that I have annexed that document.
That we have observed, that it was
Your
made
lordship has dealt
mandatory.
My lord,
from
I'll leave it to your
14/1/2016. Your lordship, that page 88, annex 6. In fact, his offline parts are there. It can be considered if your lordship directs.
Yeah.
Your lordship has page 88, annex 6.
Always. So we consider her.
Sir.
Consider her this.
Yes, my lord, that I.
experience.
But no financial benefits shall be given prospectively. That your lordship has held.
That in that
No,
judgment, your lordship.
give the notional benefit.
That
Yes,
your lordship
but-
allowed.
Your lordship in that
in
case.
that judgment,
in
my
that
lordship
your
allowed
lordship
notional.
has held that is not entitled to financial benefit, notional benefit. Your lordship.
Notional benefit.
Yeah, Lord.
Someone will cannot get the benefits of lakhs. Heard Mr. M.K. Kuntia, Land Council, Land Additional Government Advocate appearing for the appellant, as well as Mr. A. Tripathi.
My lord, one submission, my lord, without considering taking
No, I'm
the.
not recording.
Yes,
No.
my lord.
Mr. A. Tripathi, Land Council appearing for the respondent. Comment Dr. Rajat Mohanty. Stop. This intercourt appeal has been filed challenging the judgment dated, order dated 7/12/2022, delivered in WPC number 26299 of 2022 by the London Single Judge by the said judgment. By the said order dated 7/12. And single judge has observed inter alia as under. Just ellipsis dot start the cover. There exists no doubt with regard to petitioner's eligibility to be considered for promotion under DACP scheme. And accordingly, his case should have been considered along with other similarly situated person for promotion to the post of additional director level Roman 2 under DACP scheme. But only difficulty that could be visualized by this court is with regard to submission of PARs, PAR, all capital S small, through online mode, which is causing problem to the petitioner, standing as a as an obstacle on the way for consideration of petitioner's case for promotion. It has been further observed on court that it has been further observed by the learned single judge that since the hard copies of PARs/CCRs are already available with GA and PG department, the same may be called for consideration of the case of the petitioner for promotion. Further, the promotion of the petitioner to the rank of additional director 2 cannot be delayed on the premises of non-receipt of CCRs/PARs through online mode. Stop. Unquote. Having observed that a single judge has held that the petition has right to be considered for promotion to the higher rank, though the petitioners cannot claim the post is a matter of right. Stop. It has been directed that the hard copies of the CCRs/PARs being already available in the government, those shall be considered as expeditiously as possible, preferably within a period of 80 weeks, for consideration of the promotion of the petitioner to the said next grade. Similarly situated person, according to the learned single judge, has been granted the benefit on the basis of hard copies of the PARs/CCRs. Stop. The said observations and direction has been challenged in this appeal. Stop. The writ petitioner respondent, there is no dispute that the writ petitioner respondent is in the zone of consideration, and he has the right to be considered for promotion to the next grade. But for absence of PARs, CCRs online, his case was not considered. Mr. Tripathi, learned counsel, appearing for the writ petitioner respondent, has submitted that this controversy is covered by a judgment of this court in State of Orissa and others versus Dr. Kamolini Bapari. Judgment dated 28 March 2023 in WA number 731 of 2021, where this court had observed that for not uploading the PARs and CCRs online, someone cannot be deprived of the promotion. The hard copies filed in time can also be considered. And accordingly, it was directed that the selection committee shall consider the case of the respondent in that case, having regard to the relaxation as granted by the circular dated 30/4/2020. Stop. It has been further declared that the respondent in the event of his selection shall not be entitled to get any financial benefits till the date of our appointment on promotion. Mr. Khuntia Learned Counsel, while making a serious attempt to distinguish this judgment, the fact of the said case and the present one, has contended that the PPRs / CCRs for the period of 2015 to 2021 were filed by the writ petitioner respondent on 9/3/2021 after more than 5 years from the due date of filing. So for the PPERs of 2000, after about 7 years. No, this is 22. No, but the PPERs of up to 2015 to 2020. So the PPS of 2020 to 2015-27 was supposed to be filed in the year 2016.
Yes.
Stop. This way, there is a huge delay in filing these performance reports, which are essential for consideration of any promotion. That apart, the superior authority who accepts a review and reviews did not get any opportunity to review the report during the relevant time. So, however, Mr. Kuntia has, additional G has fairly submitted that the reviewing authority / accepting authority has made their comment on the bodies of the PPR those were submitted by the respondent, writ petitioner respondent. So it appears that those PPS were ready for consideration only on 25/3/2022. However, Mr. Kuntia has reported, as additional government advocate has reported that the DPC, the selection committee set on 11/10/2022 for consideration of the promotion to the next grade. Therefore, it is apparent those physical records of the PPS / CCS were available for consideration. But since the writ petitioner respondents did not upload the PPS / CCS in the online system, his performance reports were not considered and his case was discarded. Stop. The conduct of the writ petitioner respondent cannot be stated to be a proper one. The delay in filing the performance report within bracket the self-appraisal part is fatal. Stop. Sometimes there may be some problems in uploading in the online system, either for inexperience or for lacks, but that cannot be allowed to be treated as cannot be stated to be fatal in as much as the authorities have accepted the physical reports in the meanwhile. But that practice of filing physical records when the state has by the circular dated 14/1/2016 Annexure 6 to the memorandum of appeal has clearly stated that they would not entertain submission of hard copy of PAR from 1/4/2016 onwards. The officers, as employees, have a duty to comply such direction. Otherwise, they may be found guilty of insubordination. Be that as it may, in view of the law we have discussed in Dr. Komolini Vyapari Supra, we would direct the respondents
Appellant number 1.
appellant number 1.
Only one.
Only one.
Yes, ma'am.
Director has no role in this. Appellant number 1. The principal secretary to the principal secretary to the government of Orissa, general administration,
No,
public rivers.
No, my health and family welfare.
That is why. But if the secretary is not made party, this is all a gazetted post.
Yes, ma'am.
Already we stated the what too. The respondents, because these appellants. You are the only appellant.
Only, that is the only government is the
appellant. We direct the appellant to consider the case of promotion of the petitioner to the post of additional director/2 within a period of within a period of 2 months from today. 2 months is sufficient. Yes. 2 months from today. Stop. If the petitioner is found to be suitable for promotion by the selection committee, he shall be promoted to the said post from the date when his juniors are promoted in the said post. But we make it absolutely clear, till the date of the formal appointment, the writ petitioner respondent shall not get any financial benefit. His pay shall be notionally fixed from the date of his appointment and promotion, but he would get the actual financial benefit from the date of the formal appointment made by the appellant. So in terms of the above, this appeal stands disposed of. A copy of this order be furnished to Mr. Kuntial and additional government advocate forthwith. We'll come back at 2. Number 42. And Mr. Roth, just be brief.
Yes. In fact, I have prepared a bullet point. Only I'll just confine the whole matter to these 4 bullet points I have prepared for your lots of convenience and for myself also. For Lordship, kindly see these 2 pages only. Go to the
take their notes.
Primarily, these 4 points will fall for consideration. The whole entire dispute will be covered up by these 4 points, which I have tried to paraphrase. May I be permitted to place it?
Yes, please go on.
That the petitioner before the Honorable Single Judge, respondent number 1 in this writ appeal, has not placed all other prayers except prayer number B. Thereby, the order of non-extension has attained finality. Whether Honorable Single Judge is correct while directing reinstatement, which is a consequential prayer. But it is like this. To buttress this point, the respondent number 1 was a tenure-based employee. It was extended from time to time. The university decided not to extend the service any further because
Mr. Dalai, you are appearing for the university?
No, Lordship.
I am for the university.
University, really, I am.
Mr. Ratho, you are for the appellant then?
I am for the appellant.
Okay.
Lordship.
No, I think someone is opened
Yes.
unnecessarily.
So this point is like this. I'll take your lordship to the details, but in a
So according to you, only issue is now the prayer number B.
they only pressed prayer number B, which is a prayer for reinstatement.
Okay.
There are 4 prayers in the writ petition. So
Can I have a
kindly
look
see
at
those
this
4
writ
prayers.
petition? Yes.
Page
33209.
Page 82, man.
Of the writ petition?
Prayer is page 82.
Within appeal, Lordship. It is within appeal.
Mr. If you can take your seat, let me complete then.
Yes.
That will be better. Otherwise,
No, I will not confuse you.
I request Mr. Dalai to take.
No,
his
I
seat
am comfortable.
so that we can.
Why don't you sit down, Mr. Dalai?
Lordship.
Please don't mind.
No.
My younger brother. Page 82, if a lordship look at the prayer.
Yes.
Was later dated 17th of October
Who is
2020.
representing the petitioner respondent?
Beg pardon, my lord.
Who is respondent?
In fact, Lordship, I am appearing.
You are appearing for the
Yes.
petitioner respondents. Okay. So,
Petitioner before the Honorable Single Judge.
okay.
Here all.
Prayer A was later dated 17th of October 2020, Annexure 6, issued by OP number 5. Prayer B, direct OP number 5 to reinstate the petitioner to the post of Assistant Finance Officer at National Law University, Odisha, within a stipulated time period, along with all consequential benefits. Prayer C, OP number 4 may be directed to conduct an impartial and fair investigation, taking into consideration the report submitted by OP number 3 and a special audit report Annexure 7 series. Now, prayer number D, regularize services of the petitioner with effect from 14th of October 2018, along with all consequential service benefits. And further be pleased to pass any other further.
All right. The central issue is the prayer B.
Central issue is prayer A. Because his services, by that particular order, university decided not to extend his service any further.
Yes.
That order was challenged before the Honorable Single Judge. Consequently, he wanted reinstatement consequent upon setting aside of that non-extension order. Am I clear, man?
I got.
So non-extension.
The further prayer is that to regularize his services
To
with a
regularize
particular
service
date,
and to hold an investigation.
14th October.
Right.
2020.
And to hold an investigation
But
about.
what is the relation between this audit report? Because he's
that is what the
just
matter of
issue-
surprise.
demonstrated is because that on the basis of this report, his ground for termination was made out.
No. They are all completely unconnected to the petitioner.
Okay.
They are all internal affairs of the National University of Odisha. They are with regard to the contract works executed by contractors. There are some defect. Audit pointed out some objections. University was supposed to remove those audit objections, and that's their internal dispute. What the petitioner did is he had some grievance against the vice chancellor and registrar, so as to victimize them. He took away these records from the office without any authority and used it in this honorable court for an vigilance investigation against them.
Okay.
So that's one of my ground here, saying that this kind of employees should not be permitted to continue in the university. That is one of my grounds here. Now,
just you would like to see the annexure 4 also regarding the terms of the appointment.
Yes, my lord, that I'll take your lordship, kindly see. That is the
Because,
appointment order.
So Mr. Dalai was not there for the Employee in the, before the learned single
Before
judge.
the Mr. Engineer Mr. N.K. Mohanty was appealed.
Yes, I was also there, Lordship, but my power is not there.
Oh, you were
I was
there without
Lordship.
your power being there?
Lordship.
Okay.
I was there, Lordship. I was.
Page 90, would your Lordship kindly see.
90.
Page 90 of my writ appeal, running page 90.
Now we are asking you to come to the writ appeals papers. See, let us see the annexure 4 to understand the nature of appointment.
That's what annexure 4 page, running page 90.
Okay. Oh, you have annexed the writ petition with your
Whole writ petition I have annexed so that it will remove any
okay,
kind of
then we go
ambiguity
back
and
to there,
confusion.
yes.
Page 90. This is the initial order of appointment. That's got it, man.
Yes. Yes.
I am pleased to inform you that on the recommendation of the state of the selection committee of the interview held on 5th of October 2016, and in exercise of powers vested in him by virtue of National Law University Odisha Act 2008, Vice Chancellor has approved your appointment as Assistant Finance Officer on following terms and conditions. The offer being made on the following terms and conditions. One is not relevant, my lord. Kindly see 2. The post is offered initially for 1 year. The university has the right to decide upon your continuation based on your satisfactory performance. So this is a qualified term based on satisfactory performance. Then, my lord, one more important aspect is next page, my lord. Clause number 6. Clause number 6. That's got it?
Yes.
Your employment with the university may be terminated without assigning any reasons at 1 month's notice or salary in lieu thereof. And you may also have a corresponding right to terminate it at 1 month's notice or payment of salary in lieu thereof. So, what I'm trying to draw from these 2 clauses is,
yes,
extension of service is an independent contract and termination is also an independent contract of the same order. Termination is qualified by a notice or a salary in lieu of 1 month. Extension is university's authority discretion based on satisfactory performance. Now, this order was continued from time to time. If your lordship would kindly see annexure 6, page 93 of my appeal.
Yes.
I am directed to inform you.
These are all the extension orders.
This is the order of non-extension, which he challenged before the Honorable Single Judge.
You are referring to page?
Page running page 93, annexure 6.
Okay.
I am directed to inform you. Let it go.
And October 17th?
The 17th of October 2020. Hardly 4 years of service, my lord, by this time.
All right, but I'm thinking of where is this 1 month's notice and 1 month's salary in advance?
It is not a case of termination, as I have been trying to persuade your lordship. Only when we terminate, that's a stigmatic order.
Okay.
We terminate him.
So extension expired.
Yes.
Okay.
We don't terminate him.
All right. That is what I'm trying to understand.
Non-renewal
Yes.
or non-extension.
Non-extension. And for that I have placed that clause, my lord. That power is available with the university, that we have the discretion of not.
That is clear.
That is
understood.
Clear. So page 93, if lordship see.
Because the 9th October, 19th October, that is why I was thinking whether it has been termination or the extension.
Correct. Great. Great. Now, Lord, I am directed to inform you that the competent authority has decided not to grant any further extension to you as Assistant Finance Officer. You will be relieved from your duties on 19th of October 2019, 9 a.m. You are also directed to hand over charge along with all files, document, audit reports to Mr. Bibhu Prasad Kara, Assistant Register NLEO, Monday, 19th of October 2020 at 9 a.m. Thank you so much for rendering service. So, your lordship, from this order finds that it's a non-stigmatic, non-extension of service order. That's
Okay.
all.
And just come straight now to the learned single judge's observation,
Right.
how he says that it is an interferable order.
Honorable single judge says that this order of non-extension amounts to a termination order that having been taken place without a notice, the honorable single judge has interfered.
All right. That is why this also traveled through my mind for the. when
Yes,
I
my
asked you
lord. That
question.
is we have been always trying to clear that cloud, that it's a mere non-extension, non-stigmatic order. But its a third case can't be made out, referring to termination clause, which is not the case of either of the parties. If you see the writ petition, they are also here challenged non-extension of services.
So you please also come to the annexure 5 also. I think it will be better. The extension order that you passed.
Right.
Sorry, not annexure 5. It is in the writ petition.
Yes, my lord. That is page 92
Read with the
of my
first-
writ appeal,
first
page 92.
This
Appointment letter, that is. Which is the appointment letter? First engagement. This one,
Page 92, my lord, last extension.
90, offer for appointment.
page 90.
Beg pardon.
Just a minute. Just 1 minute.
Page 92, my lord.
Just one.
Dear sir,
Wait, one.
Go to the page 90.
please 90.
Annexure 4.
No, I'm going to 93.
Right.
3. 90.
University has the rights to decide upon your continuation based on your satisfactory performance. So usually for 1 year.
This is all right. Then come to 5. This is a simple extension order.
This is extension order.
All right. Now the date I like to say is up to 18th October 2019.
19.
And that has come from 19th October, right?
Right.
He was informed.
This is his service was last extended up to 18th of October
That
2019.
is why that I was just checking this date.
Right.
Okay.
And just you may see the date when we did not extend it, 17th of October.
So clause 6 of the appointment letter is
Has
not-
never been invoked.
Okay.
Has never been invoked. And if you interestingly see what is the writ petition before the Honorable Single Judge, page 64.
Page 64 of the writ appeal.
Page 64. The petitioner himself writes whether the Honorable Single Judge will be justified and correct in saying that it's a termination order. Kindly see page 64, my lord. An application under 226, 227
Yes.
of the Constitution of India 1950.
Now that is it's a very uphill task for the judges to find out whether the application is under 227 or under 226.
But he is
No,
agreed by non-extension.
That should be excluded from the practice.
Correct. But petitioner is agreed by non-extension. He also do not say that it's a termination. That's what I'm trying to tell you, Lord.
Not extending the service.
Yes.
He is saying
And look
it
at the prayer, Mihin. And kindly see page 67.
Yes.
Page 67, third line from the top. Or second line. As a result of an action of the opposite party is not extending the service of the petitioner served. Nowhere in the writ petition he says that I have been terminated.
All right. So according to you, the learned single judge has made a third case.
Third case. With great respect and humility, my lord. With great respect and humility, I say, my lord,
All right.
parties are addendum to
Just
the
a
agreement,
minute.
my lord.
Page
That's what I have been
80
saying. It's a
82.
contract.
Page 82, that is the prayer. Page 82,
Right, my lord.
that is the prayer.
That's the prayer.
After the amendment or before the amendment?
This is after.
After.
This is consolidated.
Substantial amendment here.
There also he doesn't say that I have been terminated.
To reinstate, so not challenging that thing.
The
but
prayer is to pass Annexure 6 that order I have shown to your lordship, my lord. Then to reinstate, it's a consequential prayer. Then to hold an investigation going away from everything. Investigation against the university authorities, vice chancellor, register, everybody.
Regular.
On the basis of documents. I don't know how he procured from the university office. Then to regularize.
There with him when he was working.
All right, you got it.
Now, my lord, next point is, if lordship sees, as I was trying to submit from the beginning, that part of the judgment I'll show to your lordship where the petitioner has not pressed rest of the prayers. Page 27. Part of the impugned judgment, my lord, para 5. Let's say, of course, I may be a little technical here. Your lordship may call me as a technical kind, but then that's the position of
Which
law. I'll
page?
have to
Because
press it.
2 pages are upside down in our scanned copy.
Page 27, internal page 10 of the judgment. Impugned.
Yes.
Fortunately, it's all right.
Para 5.
Page 27.
Para 10.
Para 5, my lord. In the process.
5. Yes.
In the process. In the process, engineer Mahanti, landed counsel for the petitioner, restricting his prayer to prayer number B for the time being, submitted that petition involving prayer number B should succeed.
What is time being?
All right.
So what I'm trying to tell from your lordship,
You are
as I
trying to
gave
do
in-
for the time being.
but thereafter it was never pressed.
That was not also discussed anyway.
So I'm citing a judgment on that point, my lord. Yeah, Lord, I say that the non-extension or reinstatement is a consequence of non-extension. If you do not challenge non-extension, the consequential you cannot challenge. That's the judgment.
But non-extension, he has challenged Annexure 6.
Did not press it.
Did not press.
That has attained finality. Non-extension attained finality.
Let us think that he is.
All right.
Now, Lord, that judgment is exhausted. 2010, 1 SSC page 417, para 28 to 31.
All right.
You have given some citations, it's not part of that. Some
No, this
citations-
judgment is not part of that. Today morning I only.
You are, I think you are, this placing emphasis on the paragraph 31.
Right.
To show that since the
Para
original order of the engagement was not
Great.
challenged,
I'm
that is bound by his.
Para 31. These
this
appeals are squarely covered. Right.
This.
I am deeply obliged. These appeals are squarely covered by the aforesaid judgments were of the considered opinion that in absence of challenge to the promotion of the appellant, relief of quashing the consequences in it could not be granted. But I'm trying to tell your lordship and impress upon your lordship that consequential prayer cannot be allowed unless you stick to the main prayer. And your main prayer is non-extension, which you have not pressed before the honorable single judge. Now, Lord, I'll take your lordship to that part of the judgment. Otherwise, it will be incomplete on my part, where your lordship will find that the honorable single judge has been pleased to hold that it's a termination order, the manner in which it has been held.
In which paragraph?
I'll just show to you. I'll just, in a while, I'm sorry. Lord, kindly see. Kindly see, my lord, page 41. Roman 4.
Internal page of the judgment.
Internal page 24.
Yes.
Lord, this court takes into account the submission of Mr. P.K. Ratho and counsel for the NLU in his opposition on the claim of the petitioner that for the offer of appointment allowing the petitioner to continue in such post, giving extension after extension, abruptly stopping continuation of the petitioner by Annex 6 would be amounting to termination of the petitioner in violation of clause 6 in terms and conditions is not correct. And each individual offer of extension is amounting to a new contract. Therefore, non-extension of service of the petitioner is neither amounting to disengagement, nor there was any necessity of compliance of clause 6 to the offer of appointment. On the other hand, amounting to closure of the contract, this court on reiteration of observations para 3 again in reference to condition at clause 6, the appointment extension of terms, condition service, disclosed in the appointment letter of the petitioner, being permitted to continue in last extension of service petitioner for 1 year with effect from 18th October 2019 by Annexure 5. Further finding the submission of Mr. Ratho and counsel renew so far as clause 6 of the service condition and counting with such terms and conditions, even in issuing the last extension Annexure 5, find the NLU has no other option than to undertake the exercise of non-continuation of the petitioner only in terms of clause 6 of service condition by Annexure 5. In the above stand, the university, this court finds that university is not clear in its stand that there is contradicting stand. This court finds that Annexure 6 has no legs to stand in the eye of law. It involves disengagement of an employee to the post of assistant finance officer, dehors the term Annexure 4 and 5 respectively. So now your lordship has to form an opinion and find that whether that non-extension of service within the meaning of Roman 2 of that contract between the parties, whether it's a non-extension.
Okay. Yes.
Or a termination.
All
In
right.
my humble opinion, my lord,
Yes.
since the contract between the parties bearing two independent clauses and we have not given any notice nor intend to terminate his service, it's a non-extension simpliciter without any stigma attached to the employee so that he will get employment somewhere there.
All right.
Now, my lord,
And you are refer another judgment, I believe.
I'll just coming to third point. Lord, here, if your lordship again will find that while honorable single judge is treating the non-extension as termination and violative of principles of natural justice thereafter, though it is not required for non-extension of service. Thereafter has been pleased to hold that you reinstate him immediately. You reinstate him immediately.
Okay.
Then has again gone further saying that you pay 50% of the back wages with 5% interest. In default, 8% interest.
All right.
Now, my lord, with regard to reinstatement, my submission before your lordship would be that also is against the proposition of law. The reason being, going by extreme, if you are saying that it is violative of principles of natural justice, then parties have to be relegated back to the stage from where it started. LIC of India. LIC of India. With the note of submission I have given, madam.
Yes.
Lord, LIC of India, I'll just cite that paragraph and Lord, I have given a note of submission, Lordship sees, page 14, man. Page 14. page 14, I have given this citation notes. Roman 3, 2013, 6 SCC 530, para 16, my lord.
Yes. Let's see, here. No, this is earlier.
Para 16, man.
Go above. Second one.
Time.
First
Yeah,
one is
Rajasthan
respondent
Dal.
number one. You are referring to para?
Para 16 of LIC of India case, man. I'm so sorry, my lord. It is para. I'm so sorry, my lord. It is running page 90 of my note of submissions. Para 15.1. Then para 16. Your lordship are getting my note of submission. Lordship sees running page 90 of my note of submission. When a court/tribunal
It is
Page, that
bring it
note,
as this note.
Note is the date.
Ah.
No, sorry, there are page numbers. There is 191. You are going behind.
I'm not going. Yes. You're referring para 16.
Para 15.1, I'll start referring from para 15.1, one more small paragraph only. When a court/tribunal set aside the order of punishment imposed in a disciplinary proceeding on a technical ground of non-observance of statutory provisions or for violation of principle of natural justice, then whether the superior court must provide opportunity to the disciplinary authority to take up and complete the proceeding from the point that stood vitiated. And the answer to the question number 1 is that such fresh opportunity should be given, then whether the same may be denied on the ground of delay in initiation or in conclusion of the said disciplinary proceeding. It is settled legal proposition that once the court set aside an order of punishment on the ground that inquiry was not properly conducted, the court cannot reinstate the employee. It must remit the case concerned to the disciplinary authority for it to conduct the inquiry from the point that it stood vitiated and conclude the same. ECIL so and so has been referred to.
All right.
Now, what the Honorable Single Judge, if your lordship will kindly see, Honorable Single Judge has been pleased to hold that it is violative of principles of natural justice. Then directing straight away for instant.
All right.
Then my next point only, my last submission would be, my lord.
You are arguing for respondent number 1 or
allowed it.
There is two decisions of the Supreme Court. The court can grant it despite there is no prayer.
There is also a decision master.
These four posts, last four lordship, 6 to 10, all are non-technical, and the petitioner position is their lordship. All these 6 employees lordship, along with the petitioner, they have appointed by the university lordship by the same advertisement. Then lordship kindly come to the order of appointment. That is
you are referring to which page?
Page 88 lordship, that is. Page 88 of the appeal lordship.
The advertisement.
Advertisement lordship.
All right. It is page 88.
88 lordship.
Ah.
My humble submission here, lordship. Along with the petitioner, there are other employees who are lordship. They have been appointed by the same advertisement and still they are continuing.
How that does help you?
Lordship, I'll come to that, lordship. Then lordship kindly come to the next page, annexure 4, page 90. At the cost of repetition, again, I'm drawing your lordship's kind attention. The same two provisions I'm going through, lordship. To the post is offered initially for 1 year. The university has the right to decide upon your continuation based on your satisfactory performance. Then, lordship, I'm coming to the next page, lordship. Class 6, that is pointed out, lordship. Class 6, 1 month's notice is required before termination. Then, lordship, kindly come to clause 7. That is very important. This appointment is subject to regulations of the university as may be enforced at that any time. So this is very important clause, lordship. Along with my appointment, this clause was also very much available from the day one. The regulations of the university as may be in the force at the time, that will be applicable to me. And lordship, kindly remember one aspect, lordship. Prior to that, I was not unemployed. I was working with some establishment and knowing fully well this advertisement and consequence thereupon. I applied for the post and I got selected, lordship, for the post. Then a lordship kindly started coming to bring your lordship's kind attention.
It's not readable. Give the physical copy.
Lordship, page 218, lordship.
All right. Bring it back again. Oh, this. Clear the margin, yes. Yes. Solid. Now I get it. So they have clearly stated this: the nature of engagement is contractual.
That's true, lordship. That's true. But I am relying now class 7, lordship. Class 7. Again, I am reading, lordship, for lordship's convenience. This appointment is subject to regulations of the university as may be enforced at any time. Then, lordship, kindly come to page 218. The university has taken a conscious decision, lordship. That's why, lordship, kindly come to page 218, lordship. Very same brief, lordship.
218 of the writ petition.
Miller, that is compilation of this appeal, lordship. Enter.
All right.
Page 218, lordship. They have annexed the entire writ petition.
Yes.
And all the relevant annexes, lordship, that is there. Page 218, lordship.
Two
218, lordship. Annexure 1 is there, lordship. 218.
Yes.
Lordship, this is the 1 minutes of the meeting, lordship. I'm ready. Minutes of meeting. The ordinary meeting of the Executive Council held in the conference hall of the university on today, that is 11th February 12. Following were present, lordship. Then the agendas, lordship. Data, lordship, come to page 221. Agenda number 7.
Yes.
Lordship, the Executive Council, after detailed deliberations, taking into account the financial feasibility of the regularization of non-teaching staff, approved the regularization for the employees who have put in consistently good performance for a minimum of 2 years and satisfy the eligible rules of the state government or NLU, whichever are higher. The council approved the composition of the screening committee and nominated Professor Kishan Mahajan, Dean School of Law of Executive Councils, nominee to the screening committee. But this decision had been taken way back 2012. Keeping in view, this was the regulation of the university, and keeping in mind that if I'll continue 2 years in the establishment, then I'll be regularized. For that reason, I had applied for the post, lordship.
This is not a regularization, it is a decision of a meeting.
Yes, lordship. That is the only, because in absence of, there is no rules or any policy of the university accept these regulations, Lordship,
Do
to
you really
regularize the employees of the controlling
show
employees.
from the rules? Because they have a statute, they have ordinances, show from there. Let's create, but you have to show that you
In fact,
are
my lord,
holding a right.
My lord, apart from this document,
You are,
or-
this can be shown as the administrative precedent. sir.
yes, they have taken, because
No,
Lordship,
this cannot take the place of a rule or place, or you will not confer
in
it your
absence
right.
of rules, Lordship, this is applicable to me because.
No, sorry.
Because
No,
Lordship, there is
then
no.
one day the vice chancellor will come that you have appointed me for 6 years as a contractual appointee. So let me continue.
But Lordship, kindly see, just
These are done on the basis
Lordship,
of a
come-
report,
come
on the
to-
basis of their performances and everything the university decided for regularization. It's not a matter of rule.
Lordship, kindly come to page 26, in page 43 of the judgment of Honorable Single Judge, Lordship.
Come.
Lordship,
Read.
page 23. My friend Lordship only read out Lordship page 26. Just I'm reading.
You read the later part.
Just I'm reading just next paragraph, Lordship. This court again finds, once the university decide to recruit through a regular process of selection, and in the process you select a person, though you are selecting on contractual basis, but after allowing him to continue for multiple years, you cannot leave such employee to your mercy, and there should not only be following process of law or rules prevailing may be by way of terms of conditions service, but there should also be lawful reason in taking out services of such selected persons, and failure of which there shall be no job security of the employee concerned. Here in the case, though this court finds, though the submission said that the job was provided to the petitioner on contractual basis, and a such person was not allowed to continue on the basis of certain observation of the competent authority, argument is advanced that the employer was not satisfied and continuity of such person is undesirous for the institution. The court here finds the submissions of the learned counsel for that the communication of non-continuance of the petitioner for non-stigmatic fails on its own submission. See Rath's submission that the communication of non-extension of employments does not amount to stigmatic termination found to be contrary to his own argument. So Lordship, my humble submission, Lordship, kindly see the Lordship.
Yes.
Lordship shown the nature of appointment, and along with Lordship, there are others who are employed. They have also appointed. And Lordship, kindly see, every year, looking into my performance, they have given me continuance of the renewal of my service. Perhaps Lordship, kindly remember one aspect. While giving me Lordship further continuance, there must be some conscious decision by the university, by the management Lordship. So because looking at my conduct. So what prompted them after giving me continuous renewal of the service and also giving me enhanced remuneration also, Lordship? They have enhanced the 50,000 enhanced. They have
Mr.
my
Dulu,
service.
just you focus an argument on 3 aspects of the matter.
Lordship.
The number 1 is, please analyze your nature of engagement.
Lordship.
You have yourself has read.
Lordship.
The very categorically, the beginning they stated is a contractual appointment.
Lordship.
Any engagement or appointment made under the contract will be the guiding factors for its governance and management.
Lordship.
This is number 1. 2, that your matters were extended and maybe multiple times, though we have got only one order, this is Annexure 5.
Lordship.
Right? And Annexure 5, because perhaps you have given, that is the last order of the extension.
Lordship.
So you also admit it is subject to extension. And there's clause 2. Is very categorical that on the basis of your performance, they may extend it time to time. So you know that this clause 2 guides you. It is preceded by the performance. The performance, not the case of the requirement. These are 2 things. The university may require such services, but on that basis, you cannot claim the extension. University will hold that the performance, and they are not to give any reason, because it is just simply, I will not continue the agreement. You knew that on these, when the Annexure 5 was issued, at that time you knew that this 18th October is the last date for your date. Can you on that point of time claim, no, you are bound by certain orders, principles to give me the further extension? First of all, you are not the authority to decide how good your performance was.
Definitely, Lordship.
Definitely, that is the employers.
Lordship.
Third is that if the clause 6 doesn't apply in your case, you also do not claim it is a matter of termination. Whether all the prerequisites spelled out in the clause 6, you can claim any defense upon them. Answer must be in the negative. I was also initiative after reading the judgment. I was thought that this is a case under clause 6. But now after this recording the dates and other thing, I find it simply a case of non-extension of the engagement, right?
But Lordship, my humble submission here.
No.
Kind permission from my lords, my lord. My learned senior Mr. Misra is there also appearing with me for the NLU.
All right.
Lord, I'm just take leave for 1 minute, my lord. I'll come back.
No, you can go back. That I will not also allow you to submit more. Okay. So this is the 3 aspects.
Lordship. But
because learned single judge was showing that he just presupposed your non-extension as a termination. And so for the concept in the labor and service law is concerned, contract, it is not like these casual employment. Because that we can go back to Umadevi for different reason, not for purpose of regularization. But it just extends the philosophy in the service jurisprudence that even if they are regularly appointed, they will be guided by the terms and the condition of the contract. So you are showing the other examples. In the defects in such submission, Mr. Doloi, is that the report says they are performing so well, the university can afford to regularize their services. You say, I stand at par with them, so regularize my services.
At the same time, what
No, just wait. You are missing one important point.
Lordship.
Because your engagement letter clearly spells out that it is an extension subject to the performance that will be assessed by the employer.
That is my only submission, Lordship.
Yes.
There must be some, Lordship, observation regarding my performance before taking decision.
No. They will appraise that. But on the basis of that, you cannot make out any defense because it is the satisfaction of the employer.
So my humble submission, employer cannot be can take a arbitrary decision, Lordship.
You know, there is an umpteen decision. I know there are umpteen decision where it says this is called the lift the veil theory in such this non-innocuous termination also. This is if the veil is lifted and you can find out there is a mala fide intention, and you know from 1975, from the date of the Royappa's case, the moment you will plead mala fide, the owner squarely just goes on his shoulder to prove how it is mala fide. There is no observation in the writ petition, or you have made no averment in the writ petition. This is the reason, only that audit report you have brought. I think this is not sufficient enough.
No, in fact, Lordship, that really speaks very much, Lordship.
That you have not challenged the judgment of the learned single judge. That my plea of mala fide was discarded by the learned single judge unceremoniously, and I am aggrieved by that. You have not done it. You are happy with the way the learned single judge has perceived your non-extension order as a termination order and consequential reliefs and other things they have given. You are very happy with that. But that was not your case, unfortunately.
But my entire case, Lordship, kindly see. My entire case is here, Lordship. You
just only show me where is your right to claim regularization or claim extension. That will suffice.
Lordship, my arguments in two folds, Lordship.
Yes.
Law of parity, Lordship. They are giving appointment, they are giving continuance to others on the same score, Lordship. On the same score, but without any reason, they are taking a decision.
Can these engagements are comparable?
Lordship, kindly see on the same
First of all, can this come? Because it is all individual engagement.
Lordship.
Though there was a common advertisement. There may be other employees in the similar process appointed.
Lordship, kindly have a glance to the counter what they are saying. They have appointed another contractual employee in place of mine. Lordship, kindly see.
They should, because I just indicated to you in just few minutes back.
But that is not
that
permissible.
The requirement, the service will not help you a lot. Because it is required They are not bound to appoint you.
It may not, but Lord, I cannot be replaced by
Because
another
very
set of contractual
philosophy of the
employees.
contractual employees in
Lordship.
the corporate or in the government service, now it is waiving that there is a flooding the government sector. They are taking away all the regular employments. They are all introducing the contractual appointment, outsourcing the regular posts also. That is the rule of the day.
That's true, Lordship, but what I'm challenging here, in fact, Lordship, I am taking decision-making process. And
What is-
there must be
what
some
is-
decision.
What is
Lordship,
the-
before taking a decision for
how can you
non-continuance,
question a decision-making process when there is no stigma?
there is taken, Lordship.
How can you challenge that when there is no stigma at all on you?
So that's why, Lordship, I'm
It
praying
is
a
a
Lordship.
simpliciter non-extension order.
That is the view of
No
Honorable
stigma.
That is the view of Honorable Single Judge, Lordship. While taking a
You make your submission with sufficient reasoning. I think this is not a very good case to argue. As a
then Lordship,
counsel.
I'll develop, Lordship. Let me give me a chance, Lordship. I will improve.
No chance. We have heard a lot.
No, Lordship. In fact, Lordship, it is a livelihood of a personal Lordship. And Lordship, kindly see. Lordship, kindly
Mr. Dolo, you cannot-
Lordship, kindly see.
Yes.
Lordship is a contractual employee. Lordship, kindly see the.
You just
At
show
the same
any
time,
single
Lordship should-
decision of this Supreme Court, this contractual employee has a right to get extension automatically. Because the very concept of the contractual appointment to allow you to cross the efficiency bar on the basis of these performance. That is the basic principle of the contractual employment.
But my humble submission, Lordship, in fact, Lordship, your Lordship, kindly see the Lordship
If
decision.
you want to give this note, you can provide the note.
No, Lordship, Lordship, give me a chance.
We will
Lordship,
not give you extension
Man,
of
Lordship,
time.
with
No,
great
you cannot
respect,
adjourn the
Lordship, what
matter
I'm
today.
trying to say, Lordship, kindly see. It is a life of a person, Lordship. I will try my best. Lordship, kindly give me a chance, Lordship.
You feel emotionally for that person, but sorry, the law doesn't permit us to do anything for him.
That's true, Lordship. Lordship, let down the law. I don't mind, Lordship. But Lordship, give me a chance to assist you, Lordship. Lordship will.
No.
Lordship only kind.
You argue. I'm allowing you time today, but we will not adjourn the matter, Mr. Daloi.
But Lordship, your Lordship, observe 3 points, Lordship. I want to educate myself and I will.
No, you are supposed to educate yourself because this matter has come at your instance and.
That's true, Lordship. That's true,
Yes.
Lordship.
Then-
But my impression was, Lordship, because I was going in a different angle, Lordship. And my entire argument
That
was
is
on
why
the-
we are allowing you to file a
that is
note
the
also
legitimate
because we will not
expectation,
adjourn the
Lordship.
case.
Lordship,
We will not adjourn the case, Mr.
Lordship, can you
Daloi.
see the view of the Honorable Single Judge?
Huh.
The entire judgment has
We'll
been announced.
definitely consider the views of learned single judge.
On the score of the doctrine of legitimate expectation.
But after
Lordship.
reading the judgment, my impression about the learned single judge has went to a very dizzy height. I am telling you that as a human being, his emotion for a person who has been taken off his job. But unfortunately, I have been trained as a judge to act and decide according to the law.
Definitely, Lordship. So our duty also to assist your Lordship to convince you what is the law, Lordship. So kindly give me a chance so that
No
I can
further
develop,
chance.
Lordship. I can convince Lordship. I'll take only 10 to 15 Lordship. Lordship, fix any date. I'll take only 10 to 15 minutes.
All
Lordship.
right, tomorrow at 4, come.
Tomorrow, Lordship. Tomorrow,
Huh.
in fact, Lordship, other.
No, tomorrow at 4. Tomorrow at 4. 4 to 4:30 will sit for you only. And then I will not allow the appellant counsel to argue a single word.
Lordship, can it be Monday, Lordship?
No. Sorry, not Monday. Monday is
Tomorrow-
not possible.
Tomorrow, in fact, Lordship, I have some.
Mr. Dale, it has come up on your mention.
Yeah, that's true, Lordship.
It has been preponed because you insisted that we hear it before 7.
Lordship, no, our anxiety, Lordship, always we are very much eager to get relief here, Lordship. Definitely.
Anxiety to get relief,
So
but
that's why,
when you are
Lordship,
not
I'll try
getting
my
relief
best.
doesn't mean you
I'll try
adjourn
my
the
best
matter.
to convince the Lordship. That's a Lordship fix it. So that if Lordship feel Monday, during this holidays, I'll get time to convince the Lordship.
You
I'll come with
file by Monday, you file your note that we'll consider. You give a detailed note. You give detailed note.
That's true. I will give
detailed
a note,
argument, but we will not
unless
adjust the
Lordship, I
matter.
will convince a 10 to
I-
15 minutes. I
Even after
cannot,
objection
Lordship.
of my sister judge also, I told you, come tomorrow at 4, we will hear you. I will ask the registry to for a half an hour to constitute this bench. I will not allow you time.
Lordship, tomorrow, Lordship.
Tomorrow?
Monday, better.
No,
Lordship,
not
institute.
better. Tomorrow. Come tomorrow at 4. ask the registry to make a
Lordship.
bench at 4 because after single bench, okay? All right. Only this matter will be listed and
Lordship.
only you will be allowed to just make your submission.
Lordship, grateful, Lordship.
We have heard Mr. P.K. Ratho and Senior Counsel, no, Mr. S.P. Mistral and Senior Counsel and Mr. P.K. Ratho and Senior Counsel. Who is assisting Mr. Rath?
He is also senior counsel.
Abhishek.
The name.
Abhishek Mahathir.
Mr. Abhishek Mahanti. Led counsel for the appellant in full. But at the request of Mr. S.K. Deloi, Learned Counsel. Mr. S.K. You also heard Mr. S.K. Deloi, Learned Counsel in part. For continuation of hearing, list the matter tomorrow at 4:30. No, after the rising of the single bench of Justice such and such, Oh, after rising of the single bench of the single bench, respective single benches, we made it absolutely clear. The counsel for the appellants will not be allowed to make any further submission. We would only hear Mr. Doloi and counsel appearing for the respondent number 1. And no adjournment under any circumstances will be provided by us.
Yes.
If the appellant wants to file any note, further note, you can file by tomorrow by 12 p.m. so that he can also look into your note. But don't add any additional material.
We have already filed, Madam.
Already, yeah,
Yes,
so
ma'am.
right, it's all right. All right, Mr. Doloi.
Lordship.
Call the next item.
Item 54. Item, may I please, Lordship. If the state has preferred the appeal, Lord, challenging the order, if your Lordship will find it at
54?
Annex 1. The order of the Honorable
Just,
Single Judge.
just a second. Both together. Yes.
Lord, here the state has preferred the writ appeal, Lord, assailing the legality and correctness of order dated 21st of September 21. If your Lordship will find,
Is a 144 and 146. These are against any common order.
no, my Lord, the
Two
identical order.
separate appeals.
Separate appeals,
No, come on, orders. In fact, let's same orders.
identical orders, my
Similar,
Lord.
similar.
Identical
orders,
orders.
only
The Honorable
on the
Single
same date of both orders.
Honorable
Yes.
Single Judge has relied upon a previous judgment of this Honorable Court and passed the order, my Lord. Now, my Lord, the issue here is, my Lord,
Only I have to draw that kind attention. On the same day, more than 40 cases were listed and 40 cases were allowed, and they have allowed more than 30 persons to continue. In a selective manner, they have approached in data in 2 to 3, 4 cases, 3 to 4 cases.
my Lord, that I cannot say selectively or, my Lord,
Yeah, that is
No,
also-
whether the statement is correct or not.
but then I have to ascertain, my Lord, because these files were,
I am the counsel in all those cases.
my Lord, these files were,
All right, we'll taking up the matter on Monday.
Monday.
First up this matter at 12, it will be fixed.
12.
12 p.m.
Let's see. Grateful.
Let the matter be listed on
You have
7th
to show us that these matters are not identical. If they are identical, he has a point.
because you
But
cannot treat this as our same judgment differently. That's not permissible under, not only under ethics or morality, constitutional morality, but also under Article 14 is seriously will be offended by this kind of action.
but that,
Facts are different than you point out.
And Lordship,
It has
they are
been
filing
stated
this
by Mr.
appeal,
S.K.
they
Doloi,
rely upon
Learned
judgment for
Counsel,
2 years.
that a batch of writ petitions has been decided by an identical orders passed by the learned single judge. But the state has selectively filed appeals in few cases, though they are of the same nature.
Implemented the orders in respect of others.
And
Lordship,
and in the case of the remaining writ petitioners against writ petitioners, the state has implemented the order of the learned
Lordship.
single judge. At this juncture, you are Mr.
S.N. Das, my Lord, Shalajanandan Das.
Mr. Shailajananda Das, the additional standing counsel, has submitted that he needs instruction from the appellant. Residence allowed, let the matter be listed on 7th of August at 12 p.m. Same on in the next case. Any other fixed matter?
Item 14.
My lord. 14, 1-4.
Just coming, we are coming. We are just,
Item 14, my lord.
Ah.
On behalf of Mr. Linka, my lord, kindly.
My lord.
it is 14, 1-4.
1-4.
Yes. One for the one, he said the legal aid counsel had been
Ah.
because the matter finalized and
Well.
informed him to come.
Lord, direction there.
Are you prepared, Mr. Das, today?
Not prepared, my lord, but one condonation delay petition is there, my lord.
Are you prepared?
Condemnation
My lord.
can- That is.
And the objection is not filed because the respondent is unable to move, my lord.
Yes. Let us see how many days delay.
Make your oral objections also.
My lord, before going to the condonation of delay petition, there's a peculiarity in this case. If your lordship goes to page 100 impugned order, in this case before the learned single judge, nobody appeared on behalf of the bank.
Then you did not receive notice?
No, notice was received. Notice was received, but when the matter was taken up finally, nobody appeared. It was disposed of on 5/2/2020.
Is court's a mistake or it is a court mistake?
No, I'm not a mistake. What I'm
Why then you are arguing
why
this point?
I am submitting, my lord, because in September we
You
got
cannot gloss over with your lax, okay? You come to the merit of the appeal, otherwise
merit,
the delay of almost 2 years will not condone.
434 days delay was there.
No, sorry. The delay is of the 643 days.
My lord, I would that is why I was on page 100, because there is a judgment of the apex court I have relied upon. That is
Yes,
at flag
that part
A.
you can argue.
That the
this is
date on which we got
by
notice
general
of the
waiver,
order.
yes, general.
That is from that date it is to be ascertained, my lord. So by that date, your lordship knows the extension of period of suo motu limitation of Supreme Court was there.
Up to February.
It was there. So if that period is excluded along with this fact, then there is no condonation of delay. And on that.
And that is why I am asking you argue on merit.
Yes.
Because if the delay is accepted, that they will not.
Yes. I am
Mr. Das, there is no delay.
There is no delay.
But prior to that, my lord, prior to that was after Supreme Court decision, my lord, that started from 15/3 to 2020.
The judgment was on 5/2/2020.
Prior to that, my lord, judgment was passed on 5/2/2020, my lord.
Yes.
After a lapse of 1 month, my lord,
no.
it did not prefer that, but they are taking the advantage that condemnation by taking the advantage of the Supreme Court decision, my lord. But prior to that, prior to 15/3/2020, my
There is
lord,
more than 30 days.
30, from 5/2/2020, my lord, 5/3/2020 or 6/3/2020, this will be 30 days complete, my lord. Thereafter, another 8 days, my lord.
My lord, may kindly see page 106, what I was submitting. That is the letter which we have received from the registry.
But the ground, lordship, may kindly see. The ground
that we have received on 2nd
So
September.
come on the merit of the case, because either way we are going to condone the delay.
Yes.
That is why I'm asking you, come straight on the merit of the case.
Yes,
And you take your seat and whatever the appellant want to say, let us hear.
Yes, ma'am.
The delay, we are condoning the delay.
My lord, may I please?
Just a minute to pass the order. You are Mr. Subrat Mishra?
My lord.
Heard Mr. Subrat Mishra and counsel appearing for the applicant, and also heard Mr. S.B. Das, learned legal aid counsel appearing for the respondent, within bracket the writ petitioner. There is an application for condonation of delay. There is delay according to the stump reporting of 643 days. But it appears the no waiver or exemption has been granted by the registry in view of the You to take the judgment cognizance for extension of limitation.
That is at page 11 of my miss case, my lord. That judgment I have enclosed
Page 11.
of my miss case for condemnation of delay.
What that is. No, this is a page.
It starts from page 11, my lord. There are two orders. First, the initial order, then the second order at page 13. That is annexure A by 5 series, my lord.
Just take down the name. Cognizance for extension of limitation. Within bracket. Order dated 23/3/2020. And same name. Uh, 23/9/2021. The apex court has given a general waiver for the pandemic imperatives for the period from 15/3/2020 to 2/10/2021. Is it so?
Pardon, my lord.
This extension time?
My lord, there are two orders. First,
First order, next
yes,
order.
next order is at page 13.
Give the last date. Till when was it extended?
This is not the
My
appropriate
lord,
order.
if
There
your
are
lordship will see page 13,
Why don't you give the date?
This is not the appropriate order. Other order is there.
page 14, my lord, it is there. The directions issued by the Honorable Apex Court at page 14.
The first order we are clear.
Yes, my lord.
Then
My
come
lord,
to the second.
I have submitted, though there no order is filed on the further extension, my lord, that is up to 28 February 2022. That order is not filed.
28,
15/3
20th not 20, 20.
2022.
20th
28 February
2022. Stop. The appeal, the judgment as challenged under the appeal was delivered on 5/2/2020, but the appeal was filed on 9/12/2021. Stop. The registry has the stamp report has recorded that there is a delay of 643 days. For the reason that limitation expired before the general waiver came into effect. The appeal was supposed to file on or before 4/3/2020. 6/3/2020, as the period of limitation is 30 days. But the appeal was presented on 9/12/2021. The general waiver of limitation is granted by the Supreme Court. Is on the basis of these, the public life was paralyzed for pandemic situation, and hence the said benefit has to go as a sufficient cause to the applicant also. if that period is deducted from the entire period of limitation, then there will be a delay of only 9 days. So Mr. Das Learned Counsel appearing for the opposite party number 1 has robustly stated that if the period of limitation expired before the pandemic situation, this waiver may not be granted in favor of the applicant. We are, however, not in agreement with such a reasoning for obvious reasons that the waiver also constitute a good cause for the as the paralysis of the ordinary life has been taken into cognizance by the Supreme Court while passing that general waiver. Stop. In terms of the above observation, we condone the delay. In the result, this application stands allowed. Next. Just in between, Mr. Mishra has also pointed out that on the day when the judgment was passed, there was no representation from the appellant. All right. Just because in the this admission stage we'll hear it.
Yes,
We'll not go for further stage.
My lord, may kindly
because someone is paralyzed, why the bank is coming, we don't understand.
My lord, I will point out, my lord.
Some DNA from some experienced famous play is coming into the bank's management now.
That I cannot say, but I will place, my lord, the judgment, because there are 2 points which found favor with a single judge. My lord.
Yes, come to the judgment.
My lord, page 100.
Yes.
Lordship is there. My lord, from para 4 onwards, I'll start with the background involving the case. Short background involving the case is that the petitioner joined the service of UCO Bank in 1979. In 1998, allegations were leveled against the petitioner via Annexure 1. The petitioner filed his defense statement. Being not satisfied with the defense statement of the petitioner was put under suspension. Consequently, a disciplinary proceeding was initiated involving the petitioner, and the petitioner was served with charges asking him to have his response and defense in the proceeding. The proceeding being concluded, inquiry report was submitted. Based on submission of the report, final order of punishment via Annexure 10 series was passed. Filing the appeal, the petitioner took a specific stand that once the inquiry report is submitted, before passing the final order passed by the disciplinary authority, the petitioner should have been afforded with opportunity of showing cause against the inquiry report with service of copy of inquiry report. It is alleged that even though the petitioner was asked to submit his response to the inquiry report, unfortunately no inquiry report was accompanied therein, for which the petitioner was compelled to write a letter to the disciplinary authority asking them to supply a copy of the inquiry report for his submission of defense against the inquiry report. It is further alleged that even though the communication dated 3/5/1999 via Annexure 8 provided opportunity to the petitioner to submit his response to the inquiry report on or before 14/5/99, unfortunately, in absence of supply of copy of the inquiry report, final order of punishment was passed by the disciplinary authority on 6/5/99 via Annexure 10 series, much ahead of time provided to the petitioner for submitting the response on 14/5/99.
That's actually wrong.
Sri Das Learned Counsel for the petitioner alleged that in spite of the above ground being taken in the appeal as well as revision, both the authorities have failed to appreciate such serious deficiency. Thus, Sri Das contended that there is no fair disposal of appeal and the revision, and they have all arrived at wrong and erroneous final order. Demonstrating through the document at Annexure 8, Sri Das Learned Counsel for the petitioner attempted to justify his claim on the allegation that even assuming for the sake of argument, but not admitting that the inquiry report was provided to the petitioner, but for the time stipulation therein in Annexure 8, permitting the petitioner to submit his response on or before 14/5/99, in the interest of justice, the disciplinary authority should have waited at least till 14/5/99 to proceed for final order involving the disciplinary proceeding involving the petitioner. Taking this court to the document at Annexure 10 series, learned counsel for the petitioner attempted to justify his allegation that though the petitioner had time to file his defense till 14/5/99, the final order of punishment was passed on 6/5/99. Considering the submission of the learned counsel for the petitioner and looking to the time stipulation through the communication of the disciplinary authority dated 3/5/99 at Annexure 8, this court finds there is no dispute that the petitioner was provided with opportunity to file his response to the inquiry report till 14/5/99. It is at this stage, looking at Annexure 9, this court finds for non-service of the inquiry report, the petitioner was constrained to write a letter to the disciplinary authority via Annexure 9, asking the disciplinary authority to provide a copy of the inquiry report, and this letter was issued on 10/5/99. There is no document establishing that the disciplinary authority had communicated a copy of the inquiry report after the petitioner made communication dated 10/5/95 via Annexure 9. Further perusal of the final order of punishment at Annexure 10 series, this court finds the impugned order was passed on 6/5/99. It is for the grant of time to the petitioner till 14/5/99. No final order could have been passed on 6/5/99, making the impugned order of punishment unsustainable in the eye of law. This court only on this count interferes with this impugned order. I will pause for a moment, my lord, here. The Honorable Single Judge, my lord, found two things. First, that no copy of inquiry report was served on the respondent number 1 before imposition of punishment. And the second ground by which he interfered was that though a date was given on 14/5, before that date, the order of punishment was passed. So on these two grounds, this was allowed. So may I now lead your lordship to one document at page 55, which was filed in the writ petition. Kindly see, madam. Page 55, this was a document filed in the writ petition, because your lordship will appreciate, as the bank, nobody appeared on behalf of the bank and I was subsequently given the case. I applied for certified copy of the entire records and I filed it. Kindly see, my lord. This is 20th September. They have received, I am not on that, to the Assistant General Manager, Disciplinary Authority, UCO Bank Zonal Office, Bhubaneswar. Sir, I acknowledge in receipt of your letter number so and so, dated enclosing inquiry report and calling for my reply to the same. I beg to submit my reply as under. I stand by the facts submitted through my defense brief dated 21/4/99.
Mr. Mishra, which page, please, again?
My lord, page 55 of the brief. Okay. So, my lord, in the writ petition itself.
55 of the writ petition.
In the writ appeal, my lord.
Okay.
Writ appeal number I am giving. This document formed part of the writ petition records. So there, my lord,
So
he had himself.
show it to us from the writ petition.
My lord,
We have
the
that.
certified copy is in the file of.
We have the writ petition before us. So which page was the document at?
Annexure 7A, my lord, that is what is marked there. What I'm seeing, because.
Annexure 7A.
Again. I'm sorry that.
Annexure
7A, that is what is subscribed, my lord, in my writ appeal, which was part of the writ petition records. Here I have marked it as page 55 in the appeal. That is dated 1/5/99.
Just a minute. When did you file your counter?
My lord, this is a case where the bank, though in receipt of notice, did not appear and contest the case.
No, we know that. But you're saying that is part of the counter affidavit?
No. That is part of the writ petition records filed.
Writ petition, the petitioner has given that 7A?
Yes, my lord.
Okay.
That letter is dated 1/5/99.
No, but there
Because when I got a certified copy of the records, I had filed it.
has been filed on.
What is the punishment? Termination from the.
No, my lord, not termination. Your lordship may kindly turn to page 59. Page 59, my lord, at page 62 is the punishment. The basic pay of Sri Jain Sahu be brought down to the first stage from rupees 7822 to rupees 4250 in the time scale applicable to him for a period of 5 years. During the said period, the CSO will not draw any increment on expiry of the said period of 5 years. The reduction in stages as directed will have the effect of postponing his future increments. It is further directed that the period of suspension of the CSO will be treated not having been spent on duty. Consequently, he will not be eligible for any salary increment arrears. But this is a case. I have got the list of citations. The latest decision of Supreme Court, your Lordship knows, when bank officers indulge in financial impropriety, the normal rule is dismissal.
It is a financial impropriety or is a mistake committed by the employee.
Not mistake, my lord. Here, if I have enclosed the inquiry report also.
When he was releasing the FTR, he
Pardon,
did
my
not write whether the money has been, this payment has been made to the persons who are holding the FTR.
I'm sorry, my lord, I could not hear you.
Oh, this allegations from whatever I get, there are 3 allegations were there.
My lord, at 46 are the article of charges.
Yes, come to page 46.
My lord. My lord, what? Sri Jain Sahu, while functioning as assistant manager advance at Dampara branch, had indulged in the following acts of omission and commission, which be charged as under. Sri Jain Sahu had obtained premature payment of his own FDR kept under Kuber Yojana at Dampara branch, bearing so and so dated 1/12/93 for an amount of 17,000 on 3/4/94 without marking the date of payment if the FDR register. On 23/6/95, he misled the branch by falsely reporting the loss of the said FTR and obtained duplicate purportedly in lieu of the original, whereas the said original has already been paid to him on 30/4/94. On the same day, he renewed the fraudulently obtained duplicate FDR for a period of certain months, and on 3/7/95 took payment of the renewed FDR through his State Bank account number so and so at Dampara branch. On both the occasions, all the vouchers relating to the payment were prepared and passed by him. He had perpetrated this fraud for his personal gain and at the cost of the bank. So, my lord, and he has himself, my lord, admitted that he had committed this, my lord, also. If your lordship will see, at page 40, all these documents which I am filing, your lordship will kindly appreciate, they have all been filed by him.
Ask him, page 25. It is not legible, must 25 or 30. No, this page number.
My lord, it's my fault, my lord. I had given. There are page 40 of my brief, my lord, on the right hand side top corner. Writ appeal.
Yes.
There he has also admitted. Kindly may I read it, my lord?
Yes.
There, your letter and a reference were received by you on 19/12/98, being only officer of a medium branch and tremendous pressure of work, owing to the quarterly closing of the account for quarter ending 31/12/98, and I lost mental balance after reading your same letter. I could not reply to the said letter in time. However, I am submitting my reply for your kind and sympathetic consideration. I could recollect only after the letter and a reference received by me that I had a FDR for rupees 17,000 at your Dampara branch, which I had saved out of my salary. I had also availed a loan of rupees 5,000 on 28/4/94 against the security of the same to meet some urgent domestic need on 30/4/94. When I needed some more money, I decided to prematurely close the FDR. Accordingly, I closed the FDR, adjusting the outstanding loan, and took payment of the balance proceeds. Though I myself prepared all the vouchers, I had forgotten to mark the date of payment in the FDR register and ledger at the moment, being kept busy in some other work of customer attended by table. I was seriously mentally ill, for which I continued medicine to sleep to cure mental weariness. At that time, my youngest brother became mad, who was under treatment and was also staying with me. So, dear sir, I was under terrible mental agony and was even not in position to function in the best effective manner, for this mistake happened. This mistake would have been rectified if bank had verified from supplementary vouchers to FDR register and ledger, but it was not done. After a lapse of more than 1 year, while working the FDR register, I found the said FDR was still outstanding in my name. I had totally forgotten that I had taken premature payment, the same more than a year back. Afterwards, I searched out for receipt at my home thoroughly and failed to trace out and genuinely believed that it was lost. I could not recollect I had taken the premature payment of the same more than a year. My misplaced belief was got further strengthened when I found the FDR account of the branch was balanced with my FDR. After being genuinely satisfied that I had lost the applied, I applied for a duplicate of the same, fulfilled and
Just
procedure.
for how long this respondent number was, this was under suspension?
page.
Mr. Mishra,
Pardon.
for how long the respondent number 1 was under suspension?
Ordinarily, my lord, when the article of charges are framed, then they are kept under suspension till passing of the order of the disciplinary proceeding.
Where is the, because I got the order of the suspension, but where is the revocation order?
My lord,
Suspension revocation order.
revocation order, my lord, as I was pointing out in the punishment.
Because it was on 15th January 1989, perhaps. He was suspended. No, 1999, no? Not this order of suspension.
My lord, final order was
15th January 1999.
My lord, the final order was passed on 6/5/99. So I think
No, this person is not.
till that
there.
date
The
he must be under suspension because
not also in the record. No.
Because in the punishment order it has been stated, my lord.
All right, it will be 1999.
Because in the order of punishment it has been recorded, my lord, that the period of punishment will be treated as such and he will not get any pay. And the final order was passed on 6/5/99.
Where is that final order?
My lord, it starts at page 59. Of my brief.
No, not scanning. The record is like that. You are referring to page 59.
My lord, there are, my lord, 2-page inscriptions. At the top of it is page 37, towards the bottom is 59. It's my fault, I should have erased it, my lord. That is why maybe probably lordship is having difficulty in getting it.
You are referring to the which page mark? One is inside a circle, there is a page mark.
No, the one where there is no circle, my lord.
Okay. This the order of penalty is 6/5/1999.
Yes, 6/5/99. And if your lordship will turn to page 62, where it's not enclosed, the last paragraph, my lord. The last 4 lines, my lord, it is further directed that the period of suspension of the CSO will be treated not having been spent on duty. Consequently, he will not be eligible for any salary, increment, arrears, and any other service benefits, except for subsistence allowance already drawn by it.
No, that doesn't reply my question that I say that when he was placed under suspension, maybe it is according to us, we do not read 15/1/1999. And whether at all the suspension order was revoked or it was not revoked and the final order was passed, because the date of final order is very close. Within about 4.5 months, the final order was pronounced. Then maybe it is the situation that the suspension order was not revoked at all.
But suspension order was, as far I can see from the records, was not revoked till passing of the order of punishment.
Go to the straight, go to the 6-5. Join back the service. Oh, 19 after the final order. That is not issue. I issue whether the suspension order is at all recalled or not. We don't know. Suspension order was not recalled, I think. Before the disciplinary proceeding was complete and final order was passed.
Yes, it seems from the records, my lord.
That is
Yes,
apparent,
that,
but
yes.
there is no record.
There is no record. It seems, my lord,
Yes.
the suspension period was revoked only upon passing of this final order. What is there before me, my lord? That seems
All right.
apparent from that.
Yes, Mr. Das. Because the learned single, just place it. General single judges is a premise is very categorical. That the inquiry report was not supplied to him, though he was asked for giving the representation. But it happens that you have yourself has written that I have received the inquiry report.
Your lordship, may kindly see. That inquiry report, my lord friend read, my lord.
No, this is your letter.
That letter I am reading. Your lordship, may kindly see that annexure 7A. That is, I acknowledge in receipt of your letter number, nothing is given. Enclosing inquiry officer's report, calling for my reply on the same. I beg to submit my reply as under. Replied, my lord. Signed. Thereafter, my lord.
You are reading from writ petition page number
55. Writ appeal page number 55. But it was not given, my lord. Thereafter, my lord, your lordship may kindly see annexure 9. My lord.
What not given? You have said you have received it.
Inquiry report, my lord.
Then why did you say you have received it?
No, nothing is given. What the my lord, what the son has stated, my lord, because he is unable to move, my lord. Son has stated because ordinarily that take some signature, my lord. Writing give signature. They'll fill up later on.
Dispute, but when you
That
say
is
you
why-
have received what signature?
That is why your lordship may kindly say annexure 9, that page 58. Your lordship may kindly see.
Yes.
Page 58, your lordship may kindly see. Annexure 9 of the writ petition, my lord. I had received your letter number. Some number is given, my lord. That is 3599 on dated 10/5/99 at 12:30 p.m. While I opened the above said letter, I found that yours report was not enclosed herewith. Herewith. You have directed me to submit my reply to the yours report by on or before 14/5/99.
No, question is that whether you have signed annexure this page, the documented page 55.
But no indication as to the given the what has been received.
Just please, I really understand English very little.
My lord.
Just I am reading it. What is the meaning out of it that the ordinary person will just call out? I acknowledge in receipt of your letter number blank, dated blank,
Yes.
enclosing inquiry officer's report and calling for my reply to the same.
Yes.
And thereafter,
What does it mean?
Thereafter, I beg to submit my reply.
Understand, and you are responding to that.
But
whatever the inquiry authority.
That inquiry report, my lord. I understand. Your lordship point, I understand, my lord.
Yes.
But your lordship may annexure in that inquiry report, which was received by me, by that given.
Where is that?
My lord, that is in page 65. Page 65 of the writ application.
Annexure.
Annexure 11 of the writ petition.
This is the final order.
It is the inquiry report, my lord.
Inquiry report, my lord. Annexure 11.
Yes, inquiry report.
The inquiry report.
Okay.
Yes.
Page 65, left hand side, down.
Receipt 13/5/1999.
My lord. 14/5/99 was given the time for filing by my reply. Received on 13/5/99.
Yes.
But job order was passed on 6/5.
That
Right.
we have understood.
My lord,
That
my
we
lord.
have understood.
But that's
that
why on the part of
there is
receipt of
significant
inquiry report,
difference.
your lordship may kindly see. That I'm pointing
No
out.
problem. Again, by mistake again.
My lord may visualize all these
Just a
documents
minute,
are
just
his
a
documents.
minute,
His
just a
document, I have
minute,
his documents.
Just a minute. Right, counsel, that his contention is very serious. You provided him the time to file the representation
On that,
within 14.5 and you passed the order on 6.5.
based on that, I will place a decision of the apex court, my lord.
That you can do it.
Yes, ma'am. Subject to what I will.
Show that
Yes,
decision.
my lord, I have filed it. Kindly see.
And you
My
have
lord, I
given
have given
someone
my-
the opportunity up to 14.5
My lord,
to file the representation in 6.5, you have passed the final order.
my lord, my
Which
lord, that
Supreme
is,
Court order? Let us also understand that judgment. What is that Supreme Court judgment?
my lord, I had given a list of citations dated.
No,
10
go straight to the judgment which covers this kind
Yes,
of
my
a
lord,
fact.
that is flag C. Yes, I had filed, my lord.
Flag C.
Yes, my lord.
We have up to flag B.
Flag A, flag B, I have given, my lord, 4 decisions.
Which flag? There is no flag C.
My lord, Haryana Financial Corporation and another versus Kailash Chandra Ahuja, 2008, volume 9, SEC, page 31. Sorry, 31.
That you have not placed anything here.
I had filed, my lord, two copies, my lord.
What is the name of the party you told?
My lord, Haryana Financial Corporation and another versus Kailash Chandra Ahuja, 2008, volume 9, SEC, page 31.
Another thing, Mr. Mishra, another thing strikes me that inquiry report is dated 1/5/2099. Sorry, 1/5/99. That means that
Order was passed on 6/5, my lord.
no, not that.
My lord.
On 1/5 you gave him the report. On 1/5 he gave the reply.
Pardon, my lord.
On 1/5 you supplied him the report. Inquiry report is dated 1/5. So we gave it to him the same day. He replied on the same day.
My lord, that is his document.
No, that is his document, but it's a little
My lord,
strange.
what is there on the
Because
records,
that
my lord?
Annexure 7A is dated 1/5/99.
Yes, my lord, that what he has filed, my lord, because bank did not file any counter. So at this stage, I cannot file any other document, my lord. What is there on record, I have to submit before your lordship. I cannot deviate from that, my lord. That is not permissible. So what is there on record, I have filed. I obtained certified copies, I have filed.
Can you check this letter? This one? When you
He
check
has,
received your letter
these
from
are
the
all
bank,
his documents, my lord.
inquiry report is dated 1/5/99.
So whether he has put that date 13/5/99, I cannot say, my lord.
Same day.
He is showing that next page, you just see. He is referring to this later.
No. All this has been done in express. No,
Final order.
that final order, the dates are right. The inquiry report is dated 1/5/99. I have found it just now. Where is that inquiry report again, please?
Pardon, my lord?
Annexure 11.
Annexure?
11 of the retribution. 43 जो राउंड बुला है सेगुड़ा
reproduction टा धरती तो तारी पढ़ वाला inquiry.
Yes, just show us the paragraph.
My lord?
My lord, of the judgment, my lord?
Yes.
Yes, your lordship got it.
We have took a print.
My lord, at page 39 of that judgment, that was a case where inquiry report was not given. And on that context, Honorable Apex Court on here I would want to draw that analogy to saying, my lord, what the Apex Court held, that if there is no prejudice caused to him, and natural justice is not a straitjacket formula, my lord. At page 39, your lordship may kindly see.
Having said he will receive, and then he cannot receive.
Yes.
I would rather place, my lord. I'm sorry, one more page after that. page 40, paragraph 31. No.
This is the same judgment?
Yes, yes, in the same judgment.
Yes.
Same judgment. Series of judgments have been given before that, my lord, stating that the rule of prejudice, my lord, and the principles of natural justice being flexible, they are not inflexible or rigid, and depending on the facts of a case. I am reading out paragraph 31, my lord. At the same time, however, effect of violation of the rule of audi alteram partem has to be considered. Even if hearing is not afforded to the petitioner who is sought to be affected or penalized, can it not be argued that notice would have served no purpose, or hearing could not have made any difference, or the person could not have offered any defense whatsoever?
Yes.
In this connection, it is interesting to note that under the English law, it was held few years before that non-compliance of principles of natural justice would make that order null and void, and no further inquiry was necessary. Then my lord would go
Yes,
to paragraph.
it is a judgment of the year 2007.
My lord. Yes, yes, my lord.
Right.
It is there. My lord, what
But,
I wanted to show, my lord,
All right.
at paragraph 36, I will read straight away, your lordship. The recent trend, however, is of prejudice. Even in those cases where procedural requirements have not been complied with, the action has not been held ipso facto illegal, unlawful, or void, unless it is shown that non-observance has prejudicially affected the applicant.
Yes.
Then, my lord, paragraph 38. In Jankinath Sarangi versus State of Orissa, it was contended that natural justice was violated in as much as the petitioner was not allowed to lead evidence, and the material gathered behind his back was used in determining his guilt. Dealing with the contention, the court stated, we have to look at what actual prejudice has been caused to a person by the supposed denial to him of a particular right. Then the next para, my lord. In B. Karunakar, this court considered several cases and held that it was only if the court stroke tribunal finds that the furnishing of the report would have made a difference to the result in the case that he should set aside the order of punishment. And my lord, other decisions are there. So what I want to put forth before your lordship is this.
He had made his own narrative that you have seen. He said that he was under some kind of a mistake, that whether he had taken the money, because the amount is very small, it's 17,000.
My lord, that is why I wanted to give the decision of the apex court. The latest decision, my lord, on where the apex court held along with the list of
No, this is right. Those decisions are relating to
there, the
defalcating.
apex court held, my lord, two things. One, if a manager indulges in financial
We
impropriety.
understand that the apex court holds that this is a position of trust. Certain breach is sufficient to get the order of termination.
Yes.
But you have not terminated him.
No, my lord. My lord, he is lucky. He should have been terminated, my lord.
He should
That
have
also,
been terminated.
I'm sorry, my lord, for saying this, because that is the law, my lord.
No, that is not the law.
In all cases, my lord, I've dealt with.
That is not the law, because those decisions doesn't completely wipe out the principles of the proportionality.
Yes.
Doesn't completely wipes out the principle
Yes,
of proportionality.
that is the decision I want to show, my lord, on proportionality. If
right.
a bank manager indulges in this sort of activities, what the Honorable Apex Court has held, that is the latest decision.
Right. I'm citing a decision right now. The State Bank of India versus Somarendra Endo. Read that decision. How the Supreme Court has sent the matter for reconsideration on the ground of proportionality. He was also a bank officer, bank manager, holding superior position in a big bank, in the post of this additional general manager. This decision also doesn't wipe out. Say they holds a position of trust, a little bit of deviation from that this task may invite the serious punishment. That is the observation. A complete wiping out of the proportionality doctrine is one thing, and say yes, in consideration if given, it may not be disproportionate. It all depends on the facts of a particular case.
I bow down, my lord, but here, my lord, it is not disproportionate. If it would have been these type of, my lord.
We are not on that question. We are only examining whether, as you have pointed out, that is the final point that whether any prejudice is not that.
Yes.
Someone was not allowed to say from 1991 Ramzan Khan, even Karunakar, when say the concept of the prejudice come, and Ramzan Khan was decided by a 3 judges benches of the Supreme Court. It says that the second opportunity is a valuable right for a delinquent so that he can express his view with a new perspective after the inquiry. So this is a one aspect. But Karunakar say unless it is shown that a prejudice has been caused to him for non-compliance of this right, then court may also ignore that non-compliance is a violation of the principle of natural justice, right? This is the ratio.
My lord, bow down.
Exactly.
I agree. Totally. I bow down.
So these are not the absolute rules. In service jurisprudence, normally you do not call out any absolute rules.
Yes, yes, my lord, it will depend
It's
on the facts of-
basically an administrative law.
So these are my two limbs, my lord. And the third thing I wanted to point out.
No, that is removed. After final order, automatically it should be removed.
Clear from this that earlier it was not revoked.
My lord, may kindly turn to page 103. What certain directions were issued by the Honorable Single Judge. At page 102, it starts, my lord. The impugned final order of punishment having been passed on 6/5/99 much before expiry.
All right, you have heard you. I got you.
No, my lord. Certain directions have.
You have seen these are all
complied with them.
These are all consequential.
Yes, yes, my lord. That he has not carried out, my lord. That is what I was reading out, my lord. Let me go straight away to that portion. Considering the further submission of the learned counsel for the petitioner, that in the meantime, not only 20 years have passed, and the petitioner having superannuated since long, but the petitioner for his prolonged illness also is completely unfit to speak. This court, finding the physical condition of the petitioner, not permitting to have his personal response and personal attendance to the inquiry report for the petitioner already suffering a lot involving the disciplinary proceeding, and considering the Honorable Apex Court judgment.
All right, we have seen this on
My lord, this court- no,
that
my
the
lord.
other observation made that the after the retirement, the employees-employer relationship, this is not there. This will not apply because this proceeding started when he was in service. Forget about this. We have
No, my
mentioned
lord.
in this
The
part.
Honorable Court directed that in the event the petitioner family serves on it within 2 weeks a certificate on the health of the petitioner, not enabling him either to submit his response and or attending their inquiry proceeding, to treat the disciplinary proceeding as closed and release all consequential benefits. This I was pointing. So this part, my lord, they never came to the bank after getting this order. Till now, they have never come before the bank. That is the only thing I was pointing. Para 103, the last 5-6 lines.
No, this is a there's a lot of apparent contradictions that I'm telling you how we are reading it. He says in view of the judgment of the Supreme Court 1995 SC, that is the preceding judgment of this Tank's judgment.
My lord.
The observing that after the superannuation relationship of the master and servant ceases, the consequently disciplinary proceeding lapses on superannuation. Right.
My lord.
This court directs that the disciplinary authority that in the event of the petitioner family serves on it within 2 weeks a certificate of the health, or the petition not enabling him either to submit his response or attending the inquiry proceeding, to treat the disciplinary proceeding closed and release all the consequential benefit.
How, my lord? How to?
Because this first part, if you read, it appears to us that he says there is no disciplinary proceeding cannot survive anymore since he has retired. Right on the next day, says that he should file a response. Where to file the response?
That how, if your lordship.
No, just come. First, understand the judgment.
Yes.
He says there is no disciplinary proceeding survive because he has
Superannuated.
so he's superannuated, right? Then say that within 2 weeks, if he files, then it will be considered. Where to file if the disciplinary proceeding is not survived? So these are some contradictions are there here and there. We have to edge out those contradictions. Mr. Das, you have to show this one of his judgment he has shown regarding the prejudice, how you have suffered the prejudice. From the writ petition, you show us how you suffered the prejudice not for non-filing of the
Pointed, my lord, one
representation.
thing, what my lord has submitted, my lord.
I think he has completed.
My lord.
Yes.
I have submitted as to counter my submission of my friend, my lord. My lord, the honorable single judge, my lord, held, my lord, even though assuming that the inquiry report has been submitted.
Yes.
Then, if you have given the time for 14 for filing your reply by 14/5/99, how you deliver the
No. This is a proposition is that even if you are not given any chance, right?
Yes.
Even if you are not given, you are thus assuming that you are given a chance, you have the inquiry report, you are giving a time to file the reply before the judgment has been pronounced. According to you, it is a 14/5, but judgment was pronounced on 6/5.
6/5.
So this is it. The decision of the Supreme Court says, even if it is not given,
Yes. Yes.
even then you are under obligation to show that a prejudice has been caused to you for non-filing of the representation.
That means
My lord,
suppose
my lord.
it had been given to you, how will you improve your case?
My lord, your lordship, I say just to that extent I will submit. My lord, reply, not initial reply. What he has stated, due to mistake, this has been done. But that amount was paid back. Besides this also, another 70,000, I'm pointing out, my lord, 70,000, 17,000 and some odd, my lord, that was also paid. After the payment is made, they made such a disciplinary posting, my lord. Your lordship, I will draw your lordship's attention.
Because you admitted everything thereafter.
My lord, admitted because it is stated, my lord. There was a number
the
of
reason why you have not been dismissed from the service.
Because you returned the money.
You return the money, they believe partly of your story.
commercial rate also, the interest was also paid, my lord.
All right.
Thereafter, I was continuing, but subsequently they be inserted posting, my lord. Your lordship, may kindly see.
Continuing.
Have you received the pensionary benefits?
Yes, my lord, kindly see, I am showing.
I have to take his
My lord,
otherwise, he is
as
not
per
in a book.
terms of the
He is
punishment
not in a
order,
book. He is a coma stage.
I understand, but he can speak
Client
out.
standing behind you, you find out.
all his retirement benefits have been paid, my lord, and the original letter which they had sent, I am giving.
Okay.
Just ask him whether he has received I think he is not the person, his son.
Yes, my
He
lord.
may say also whether received the benefits.
Oh, what?
My lord, whatever benefits were due to him have long since been paid. 2 copies I am giving to your lordship. And as far as repayment is concerned, my lord, that judgment I am giving of the apex court, that will not wash away his sin. Kindly see.
That is there still the misconduct of temporary defalcation.
Para 8, my lord, may see that judgment of this.
In fact, that
You
is
just give us this copy by photocopying these things. These documents. I think you are giving the original.
Yes, original I had with me, ma'am.
No, just
To
give the
show your lordship
photocopy.
that all his payments dehors the
So
punishment.
give us
of
the
this.
photocopy.
exactly give us the supporting document. तो गोटे धड़ा कागज देले मेमो सहित गोटे दे देबे से गोटे कोन डॉक्यूमेंट देले मिस्टर मिश्रा जस्ट गिव द लिस्ट विथ द मेमो अदरवाइज विल गेट मिसप्लेस्ड
Xerox copy, photocopy.
धड़ा कागज गोटे तुम दे दियो
Mr. Dash,
Paragraph 50.
since you are the mic for the court, by tomorrow, do some research whether you judgment you get.
My lord.
Do some research if you get to judgment to cover these 2 decisions. One is of this 1994 and 95. In 2 journals, 2 reporting is there. Karunakar, B.V. Karunakar's judgment that actually virtually brought this concept of the prejudice. And subsequent decision he has given. This is Haryana Financial Corporation and Nandar versus Kailash Chandra Ahuja.
My lord.
These 2 decisions. And if you Kailash Chandra Ahuja, if you want to see, you can get
My lord,
a
I am giving
photocopy.
a copy of my list of citations.
All right. All right.
I'll see.
But we are considering only 2 citations, B.V. Karunakar and this one.
Yes, but that there rests my entire case.
And
my
now
lord.
you are giving
One is factual, one is legal.
report. Now you are giving one report right now regarding this
Payment of the retirement benefits, my lord.
where is that judgment?
That copy.
That copy I had given, my lord.
Copy में you supply me copy कर देखो very number कॉल लिखी दियो तो copy कॉल कर 943722 7379 3722 7379
Yes, given as a different
List of citations. Mr. Mishra, list of citations you had filed earlier.
Yes, madam.
So this is that same thing.
Yes, madam, same thing.
That is scanned.
And this is one, along with the list of dates, that additional one I had given, that paragraph 8. I had pointed out, my lord, what,
You filed it today.
no, this is that is with the list of dates I'm giving that additional citation. That paragraph 8, there also, he had taken the money, my lord, I had returned,
This I've seen.
my lord.
The judgment I know.
I'm giving this second copy.
All right. That's all. Would you like to just research for tomorrow? Just give the judgments to us. We are marking it reserved.
Okay, my lord, I'll file tomorrow, my
My
lord.
lord, second copy of list of dates for Honorable Justice Ratho, I'm giving that.
All right. This bundle has come from your side, no?
No, this is the original reproduction. I was showing you the documents from that.
All right,
because
all right.
In the rate of fail, half of it has been scanned, but the document is
All
incomplete.
right.
Here the complete one is there.
This, just make a copy of the digital record also, no? I mark something there.
And this, will you give it the rate of fail or you don't give it?
No, it is.
The rate of fail side the convicted. Yeah. First copy saying they do it.
Yes. Where is that? Ask for yourself.
Item 72.
Item
Yes.
72, I filed a status report. My lord, actually the order dated, last order showed that if status report is not filed today, then the IAC shall appear. But inadvertently, I think there's a noting that personal appearance, but however, he's there on the virtual
All
mode.
right. We will go by the orders. Don't worry.
No, they think even then he's not. What's your mode?
Because I had communicated the order to him last week, so.
Ita bandhile. Second copy ita bandhile. Put lo to site additional ones for that.
No development, just they are trying, they are going here and there.
The-
Stress.
The IO is doing nothing, my lord. He is moving in the village area, Saidnagar area, in the village.
Take a photograph.
But IO is not taking any steps, my lord.
I have asked the IAC that, but your lordship can see the last line of the status report, which I cannot reveal in the court, my lord. So they are keeping a constant vigil on it. So now the IAC is also online.
We are
virtual.
giving a further time up to 10th. You have to.
My lord,
All the time it's like a lollipop to the court. When you are showing this you got, but thereafter nothing is
no,
happening.
they have done, my lord. So unless the mobile phones have been switched off, that is
Now
what
you say that you are in a some
of the relatives.
then the police in order to locate the victim girl. We express our serious annoyance, but at the request of Ms. Patnaik and additional government advocate, we provide the further time let the matter be listed on 11th August 2023. The IIC Shohid Nagar Police Station will personally monitor the case and take action as required to recover the victim girl by the next date. A copy of this order is supplied to Ms. Patnaik and Council forthwith. However, we return the status report as produced before us as some vulnerable information has been disclosed in the said report.
Item 24, it's a fresh matter. If it can be taken up tomorrow, your lordship.
tomorrow or some
Well, there is a
Monday.
contempt on which is to be listed on 11th August. Any
No,
date
don't
before
take
that?
on Monday, 7th.
Monday, your lordship.
My lord,
Monday,
item
make it on
20
7th.
item 27,
24.
24. It's a fresh matter.
item 27, my lord.
Ah.
Yesterday I made mention that termination, that university batch of cases was there. My case was tagged, but no interim order could have been passed.
Today,
So tomorrow, my lord, only
Justice
the same
Ratho has a
interim order
meeting,
is.
otherwise I would continue up to 7. There is no difficulty.
No, not.
No, no,
Only I
there's
pray,
a
only I
issue,
pray, my
because
lord,
lot of
tomorrow.
matters are coming up, we cannot take up because one matter is taken up for hearing, then the entire
That
things are topsy-turvy
my lord,
already.
only is a fresh case, my lord. Only 27 item tomorrow, my lord. I
could have
will hand
mentioned
over
the-
the order passed, my lord, in that WPC
tomorrow-
107.
Mr. Das, you would have mentioned in the first hour, you could have taken up. We
No,
could
I
have
will
coordinated
you-
something.
All
I
right,
thought it will
tomorrow,
reach.
all right, tomorrow 12:30 I'm fixing the matter.
Obligation.
My lords, item number 40 was mentioned today, we taken up at 2 p.m. Your lordship had directed. But there were
but
other matters which took.
Can it be also tomorrow, there is any matter tomorrow 2 p.m.?
2 p.m. is.
May I pray, your lordship may take it up on Wednesday at 2 p.m. Wednesday at 2 p.m.
Wednesday.
Because Monday, Tuesday, I.
Monday, Tuesday.
No, to Wednesday there is certain difficulty. I make it of 10th. 10th of August.
10th. Thursday.
Lordship, item 34.
69.
PM, my lords.
2 p.m.
At 2 p.m. Oblige.
Item 69, lordship, with the item 69. The minor girl kidnapping case, my lord, they have taken several adjournment for trace out the minor girl.
They are not adjournment, they are trying to locate. You are saying your minor girl, but the person with whom she has gone out, we do not know what is the purpose. Always don't blame the police. We are blaming the police sufficiently.
They have taken several adjournment for trace out the.
Item 69.
Yes, yes.
Regular status report has been filed, my lord. Last also it say that.
To form a special cell department for
That
this.
is what I have discussed with the CP. He also is offering that
We have
they,
to,
if you give a.
make a research regarding the psychology and everything. Maybe hold some in the bus.
There is one special scale like Muskan in which they were trying to rescue this.
Muskan is a network for the traffic girls. It is not.
That was
nothing
for
to do with-
trafficking,
no,
yes,
not- nothing to
but
do
not
with
for
the,
these cases. Yes.
Individual cases.
Individual cases
And schools and busties, you have to also have these programs, counseling programs.
No, Mr. Mohanty,
Minors run away.
Yes, they don't know.
we are fixing this case on 10th again.
But item 50, Lord, I have
Girls have been
mentioned.
rescued, if your lordship will say, that can.
You have rescued somebody out of this?
Yes.
One rescue matter is there. Which one?
At
One
the
out of
request
10.
Mrs. Patnaik and additional government advocate.
Item 28.
Item good item.
Let the matter be listed again on 10/8/2022.
This one is going to 10th. 10th.
10th, yes.
In the meanwhile.
Lordship, item 34.
Mr. Vishwal, please wait. Order is being dictated.
All efforts shall be taken by the police in order to locate and rescue the victim girl. Stop. The further status report by incorporating the actions taken by the police be filed on the next date.
Rescued one will take up.
Item 28, the girl has been rescued.
Item 32. Item 30.
Who is appearing for the petitioner? Anyone there for item 22, 28?
Has been rescued.
28.
Rescued.
She has been rescued on 13/7/2023.
On behalf of Mr. Tripathi.
The girl has been rescued. We are
Rescued.
closing the proceeding.
Okay,
Stop.
my lord.
Mrs. Patnaik, Lanet, additional government advocate appearing for the state has submitted a status report. Stuff. It transpired from the said report that the minor victim girl has appeared
This is she's saying nobody has kidnapped her, but police is attempting to arrest the accused. I can't understand.
His surfaced,
Minor.
stop. Her statement under section 164 of the CRPC.
That is her
been
statement, but the
recorded at
parents
the
are given.
instance of the investigating officer. Stop.
Minor.
Since the minor victim has been recovered, but resurfaced, this proceeding stands closed.
After
Madam, but
6 months, there will
item
be another
Lord,
case.
today mentioned in the morning.
Item?
Item 50. Lords, you kindly give him
Five-
short date 50.
five-
50. Any short date, Lordship.
Another
I
case-
am appearing for the private opposite part number 5. I need 2 weeks time to file counter, my lord, because 3 cases has been filed.
50.
Yes, Lord. In the month of April, it has been granted to file counter. They have not filed. 4 months has lapsed. Yes,
My
sir.
lord, my
Yes.
lord. The PIL excise PIL.
Lords, you can grant some.
Item 71
Let
also.
be granted some time. Lords, you may fix a date.
30th of August. we are
Lords,
fixing the
Item
matter.
32,
Item-
Milord.
Place the matter on 30th
Milord's
of
item-
August.
Item 32, Milord.
At the request of the council, Mr. He has left already.
Item,
What is his name? Appearing for the
item
opposite party.
32, Milord.
At the request of Mr. BP Das, Land Council, he is appearing for whom?
My lord,
Item 32, Milord.
Item 71 also another.
Mr. Das, you are appearing for opposite party number? Mr. Das. Mr. Biraja Prasanna Das.
Private opposite party. One.
Appearing for opposite party number 5.
Opposite party number 5.
All the
Let
cases.
Let the matter be listed on 30 August 2023. Meanwhile, the opposite parties shall invariably file their reply as no further accommodation will be made.
My lord, item 32, Milord. 32, Milord. Can I be taken?
Just I am taking the matter.
Milord, item 32.
Your matter will not be fixed.
Milord,
Just wait. You are breaking the line. Just wait.
Item
Yes. What is
32,
your
Milord.
matter?
Item 32, Milord. Can it be 9th, Milord, 2 p.m., Milord?
Let us see.
9th, no matter on 9th.
10th, 2 p.m., Milord. So yesterday, last occasion, I have
14,
mentioned
14
that.
August,
matter, Milord.
14th,
14th.
25.
My lord.
23. It will be taken up on 23rd of August.
Item, I will be absent. Milord.
Item
So that's it.
34, Lordship, I'm
Milord,
sorry.
before that, 18th, Milord.
No,
Milord,
there's no, because it will be coming and this situation will be again re-emerged.
Lordship, 28th, 28th.
28th already.
Okay.
28th.
Well, item number 44.
2
Item
p.m.,
number
Milord. 2 p.m., Milord.
44.
2 p.m.
44.
Okay.
Item number 44, my lord. It's a case of regulation in whose light my case was allowed, my lord. That has been dismissed by this division bench on 12/4/2023, my lords. I pray this matter to be taken up short date, my lords.
Item
23rd.
Oh, it's division bench dismissal.
Date
Why
September.
are you making wrong submission?
In whose light my case was
No,
allowed.
that is not similar to that case.
5th of September.
Lordship, item 34, Lordship. I mean virtual mode, Lordship.
44. It will come on 5th of September.
Yes, my
Item
lord.
item
46, my lord.
Item
My lord, item
5th of
46.
September.
Item.
My lord, item 46, I made a mention in the morning, my
Interim
lord.
order to
A short
continue,
date
my
may
lord.
be given.
We have 47 days.
In that 44, interim order to continue.
31st of August. 44.
Item 62, your lordship.
Lordship. What is there? Item 44. There is
Item
interim
6, my
order.
lord.
Your matter is 46.
My 46, I made a mention, short date.
Item
47.
Item 60.
47.
Yes, ma'am.
46.
44.
Oh,
Yes.
5th, all right. This 44, right? The
But
interim
interim
order
order.
is passed earlier shall continue till the next date, not until further orders. Yes.
Item 19.
Item 1919.
19.
Yes.
What is your prayer?
Look there. The notice was issued in the limitation matter as well as in the writ appeal also. The notice, undelivered notice has returned. that the addressee is not found. So I will take fresh steps within 10 days.
Item number 19. The appellant shall take fresh steps for service on whom?
On the sole respondent.
Service from the sole respondents, as the notices are issued earlier could not be served. Mr. P.K. Muduri, learned additional government advocate, has appeared for the appellant.
Unutilized copy may be utilized. I will file the postal.
This appellant be allowed to use the unutilized requisites for purpose of fresh service.
Interim order to contact.
Item 60.
Notice is returnable on 14/9.
Item 62. In the morning, half.
Interim order.
One by one.
Item 19, interim order is there.
Item 19, interim order is passed earlier, shall continue to.
Item 25, my lord, on my mention it has come.
My lord, item 22.
25 on my mention it has come, the fresh matter, delay of 47 days.
No, notice has not been issued?
No, not issued. Fresh matter, only.
Item 22.
Item 25.
22.
25.
Item 47, your lordship.
My lord, item 22.
25, no defect is there. I have
Item
already
25, okay.
Item 47, your lordship, I'm appearing through the BC.
22, my lord.
He is Mr. Moral, no?
22, item 22.
Heard Mr. P.K. Saul and counsel appearing with the applicant. There is an application under section 5 of the Limitation Act. There is a delay of
47 days as per my.
48 days as per the stamp reporter. Stop. In filing the intercourt appeal against the order dated 13/4/2023, delivered in WPC number 1676 up to 2020 by the learned single judge. Issue notices to why. Just copy the limitation matter. Notice is made returnable on 21 September 2023. Steps for service on the
Notice on private party OP3 only.
The sense who is appearing for the state in this matter?
State 1 and 2.
Who is appearing for the state in this matter?
I am. In that case, I am.
1 and 2. Yes.
Mr. Peak, since Mr.
Kuntiya.
M.K. Kuntiya, learned additional government advocate, appears in web's notice for the opposite parties number 1 and 2. No formal notice is called for in respect of those respondent. However, the applicant shall take steps for service of notice on the opposite party number 3 within 5 days from today by registered post with AD. So take steps.
Item 49. Lord, item 49. 499. Lord, the judicial employee specially assigned to this bench and penalty has been imposed. Lords may keep it on Monday. I pray on Monday. 49 months.
Yes.
Specially assigned to this bench.
What is the subject matter?
Subject matter, punishment has been imposed, your lordship.
Right. Right.
Lordship, I pray, my lord, Monday, your lordship.
Okay. Keep on Monday.
Items.
You mention in the mention hour to upgrade the matter.
Yes.
Item 62, your lordship. In the morning session, I learned an advocate, Mr. Tripathi, made a mention. This matter is with regard to recruitment, your lordship. Therefore, a short date may be fixed. Otherwise,
on the 31st of August.
Pardon, your lordship. If the corporation will give appointment, the matter will be infructuous.
No, but we are issuing the 31st of August this month.
Yeah, earlier, your lordship, already they have made the computer-based CBT test, your lordship. Once they will give the appointment, it will be infructuous.
Have you filed any application for stay?
Pardon, your lordship. I am the respondent, your lordship.
You can file an application for stay if the matter is not heard. Any stay order is there.
Yes, government petition went in appeal.
A single judge has decided in your favor.
Yes, your lordship.
So they have obtained this stay order.
Stay, that is operating against me, your lordship.
But Mr. Kuntiya, during
I'm appearing in this matter.
There are two matters, your lordship. One is 910, writ appeal 910, and another one is writ appeal 911, your lordship. In 911, I am the opposite party. I am the sole respondent in that case, your lordship. I succeeded in the first case. against the interim order, the OPTCL went in appeal. And in absence of me, that order has been passed.
Well, the learned single judge directed that in the interim, the petitioner will be allowed to appear in the examination. The order was unimplementable. It was passed on 1st of May and the examination was on 5th of May. Therefore, I approached your lordships that the order is not implementable and your lordships have granted a stay.
Yes.
In the meantime, the results of the recruitment test have already been published.
That is what he's saying, that it will become
That's why I'm
infructuous.
saying that this matter needs.
It may be taken up any date next week, your lordship.
All right, 14th of August, you are
Great.
taking the matter.
May I
Is it
pray
fixed
only
date?
one thing? Lordship, can you fix it time in this case?
14th of August, we cannot fix time. That is a problem.
I know.
Today we fixed time for your matter.
First hour.
Did we? What
If
does
you-
it
if it
produce
will
the
be, if
result?
it will be fixed at 2 p.m., then it can be. I
No,
hope and
2
trust
p.m.
upon
already
this court.
matters are already fixed.
My lord-
Some matters.
My lord, item 22.
Yes.
It may taken up any day, but in the meantime, they are also not obliged the order passed by this honorable court. May grant the stay of the execution of the order.
How can you say that I have not, my lord, in this case, your lordship has directed me to obtain instructions.
Yes.
The concerned executive engineer I have called, he is sitting that what is the position. And what he is saying, we have already constructed the.
No, you are misleading the
you are
court.
saying-
You are misleading the court. Once there was a compromise arrived between the parties, you should abide by the compromise. But you are now flouting the order passed by the honorable. Basing on that compromise, contempt which has been
Mr.
dropped.
Ponda, why are you shouting?
No,
You
you
will
are
shout
shouting.
like this and
What-
you
what-
allow
you
others
are-
to say.
No, you are.
By shouting, you cannot improve your case. You.
Don't tender any
the-
sorts of advice to me, please. Sir,
The officer
there
will
was
present
a,
your lordship.
sir, the compor
20th. They fix on 20th.
My
It
lord,
will come on 20th of August.
20th, till
20th
then,
of
till then
August.
status quo
No,
land
Mr.
to be continued.
No status quo. You
Compromise, sir,
Status quo.
compromise was there. My lord also have compromise
That
was
we have
there.
seen
They are not.
this, and we have seen this, what kind of compromise that was. That is why I asked him to take the instruction.
Yes.
Let the matter be listed on 20th of August 2020. 21st, okay.
21st.
All right, any other mention, Madam?
My lord, item
Item number 47,
1 minute.
your
Two
lordship,
matters.
item number 47.
Sir, they are for interim order continuance.
It had come to the bench after
Item-
my
Mr.
mentioning.
Sorry.
Yes, item number 47. I had mentioned this matter and hence it has come to the bench. Item number 47, may it be listed on Monday?
There's
What
a
is it?
lot of matters on board.
What is the urgency, madam?
Ma'am, it is the discharge of toxic waste into the river water.
Okay.
It's a PIL matter. May a time be fixed
Water in the river.
around
Alright.
12.
All right, it will come on Monday.
Okay, much obliged.
Yes,
My lord, item 61.
I am asking him.
Hello.
Yes.
I
Yes,
will be
sir.
pardoned to make mention, my lord, item number 30, my lord.
Yes.
That relates to Sishu Bhavan, my lord. This matter we listed as per your lordship direction. The Secretary Health and Family Welfare Department has to appear before your lordship in person, my lord. This is a very serious matter. They are not implementing the order and direction of this court and the authorities. And
We are not implementing.
They
As
are-
per your lordship's direction, today I have filed the personal affidavit of the Secretary Health and Family Welfare.
but
You
that,
supplied the copy to him.
my lord,
I have served a copy.
but they have served the copy, but the copy which have been served that they have not complied. For that reasons, I want to
That
draw
is
your
a-
lord.
That
the
is his
matter-
allegation,
my
but
lord-
my
my-
assertion in the affidavit that we have complied, whatever,
may
to
I-
what extent, that
May
is
I-
the
may I-
matter to be
may-
argued.
argued. May I pray, my lord, if it will not be inconvenient, if the matter can be taken up tomorrow or
Tomorrow.
on
5
Monday. It's a very serious matter. The children are suffering a lot, my lord.
All right, on this, on Monday.
Monday,
This
my lord.
Yes.
Obliged.
So you have filed the affidavit, personal affidavit. you
Yes,
have
I have
filed.
filed the personal affidavit. Since long it is filed, my lord.
All right,
Not on 1st August, they have only served
all
the
right,
copy.
all right.
Item 56 and 60, interim order to continue.
56 and 60.
60.
All right,
And-
56 and 60 is the
And-
matter on 5th of September. 5th of September.
63 also. 63. Three
60
matters.
63, I am to the respondent.
Just wait. You are mentioning which matter?
Three matters, my lord,
Ah.
56, 60 and 63.
63, all the matters on.
My lord,
file,
63.
Ah.
I am for the respondent, madam.
Ah.
So stay is continuing, my lord. So it can be only the with regard to the peon in the district treasury office claiming regulation, honorable single judge has allowed my prayer, madam.
Naturally, that is why the
That is
appeal
why
has
you
been
are
filed.
fixing the date for
Short
final
date.
hearing,
So short date, your lordship.
5th of September.
Ma'am.
5th is, in the meanwhile, the interim order is passed, you shall continue in 3 matters. Okay.
My lord, item 61, my lord.
Ah.
First, I have mentioned matter may be taken, given any short date, I have not getting my salary since 10 months. The appellant was not giving during pendency of the rate appeal. I have not get my salary, madam.
17th of August.
My lord, I am for the appellant, madam.
And 21st.
What is this, Anganwadi?
No, my lord.
22nd it will come. 22nd of this month, 22nd August. All right.
My lord, the appellant is here, my lord. He will release my salary.
My lord, I assure before my lords, will release the salary.
All right, all right. List
That order, my
22nd of August. All right.
I may be discharged, but I have filed also.
All right, you filed all the,
My
on
lord,
that
the-
day will consider.
Most controversial matter, item 34, my lord.
What is the controversial matter?
That
All
is
the matters are
regarding the
controversial.
life of the prawn
Policy
carry.
Chilika, lordship, and last occasion, lordship directed to frame a Chilika policy to prevail peace in Chilika lordship. The issue of fishermen and fishermen and all stakeholders of the Chilika lordship, because the entire livelihood depends upon Chilika.
That is one part.
Because
Other part is the cultivation of prawn in the within Chilika as well as in Bhitarkanika area, nearby area, my lord. Your lordship have directed the CA authority, Coastal Aquaculture Authority, Chennai, to consider the applications which have been recommended by a district level committee and dispose of the said application. Till today, those applications have not been disposed of by the Coastal
Mr.
Aquaculture.
Mohanty, you take note of
Mr.
that.
Mohanty is not.
My lord, I am not there.
The council.
DSA is to address the.
You are there?
Deputy Solicitor.
You are there.
He is with me. He is for Chilika, so far concerned, their Deputy Solicitor General will address the issue raised by Mr.
All right, Mr. Paddy.
So far as.
Pardon,
CC here?
Therefore, your lordship may fix a date. Today it is not possible. Fix a date,
Any
my
date,
lord, at any
because
date.
usually this matter taken about 2 o'clock, lordship.
2 o'clock
All
it
the
can be,
occasions, it was
yes.
fixed at 2 o'clock. But for the first time, lordship, day
It will
before
serve the
lordship.
public in.
Your lordship is taking up this matter.
Lordship, sorry, lordship.
So when can we fix, give the date?
Oh, God. it is-
Give the date. 28th of August.
8th of August. My lord, at 2 p.m. your lordship
All
kindly.
No, no, we are mentioning on that day you mentioned.
My lord, we have filed we have filed 4 affidavits in this, because on each date we used to file affidavits of each district regarding the developments. We have filed today 4 affidavits. 4. It may kindly note that.
All right, it is,
The
you are
affidavits filed-
appearing for whom? Opposite party number?
Yes, madam. By this, by the Tahsildars, I am just placing. In fact, lordship, there are 2 directions. One is routine demolition. They are, lordship, taking up the routine demolition, they are filing affidavits. At the same time, lordship, last occasion had given a direction to frame a Chilika policy only to prevail peace inside Chilika. So, lordship, that the time frame was given, lordship, to frame policy. In fact, that only inaction of the state government, because it's creating all the difficulties. They should come up with a Chilika policy
Yes,
so that
you are appearing for whom?
state government, lordship, they are appearing.
the state government.
No, no, opposite parties number 1.
There are
Number, there are 10, I think. There are
in fact,
10
lordship,
and 11.
there are more than
Mr. B.K. Mohanty, learned additional government advocate, and Mr. I. Mohanty.
Ishwar Mahanti is assistant.
I. Mohanty is not sufficient.
Yes, yes.
Now, there may be confusion, then I can write the full name.
Sorry.
Learned additional standing council. Appearing for the opposite party number?
Madam, state opposite party, because there are many opposite parties.
Opposite party and state opposite parties have submitted that they have filed the 4 separate affidavits.
My lord, one by one, let me sum up. First affidavit is by collector Puri.
Stated that the separate affidavit has been filed by the collector Puri
Collector Puri,
and comma, just what after comma, whose name will come?
Tahsildar Ganjam, Tahsildar Ganjam,
Tahsildar Ganjam,
Tahsildar Chilka,
Tahsildar Chilika,
The Pune list is.
And
Tahsildar Rajnagar.
Tahsildar
I am
Rajnagar after
content with that,
supplying
my lord. The copy may be
copies
served
to
on-
the,
the copy may be served on.
have you not supplied the copies?
Lordship, in this case, we have not get the copy, Lordship. Our case is against the Tahsildar Chilka, Lordship. What the Tahsildar Chilka is doing, he is demolishing the private land, Lordship, by using cochlear.
I am directing the
Tahsildar
special copy.
My lord, may kindly
Biswal.
consider.
Be
Mr.
careful,
Biswal,
be
we are
careful of your pen, Mr. Biswal.
Lordship, I am
Hello,
sorry
all
to
Mr.
say.
Mohanty, no,
My
Mr.
lord-
Mohanty, learned additional government advocate is request to supply the copy of the all the
Affidavits.
councils.
Affidavit.
My lord,
who is
all these
appearing for-
affidavits are usually given to the amicus curiae,
No,
Mr.
no,
Mohit Agarwal.
we are
because
also
he is
lordship,
concerned
we are the stakeholders
because
lordship.
they are not concerned with
Definitely,
these issues.
we are raising.
They are having separate
party.
cases.
Lordship, because of
Different
we, the
cases.
cases come up here, lordship.
We are
Because of
party,
we,
my lord.
who is
No,
amicus?
you just check up, you give the copies to the council.
Yes.
who
We
is
are party,
appearing.
my
We are agreed parties
He
and.
is requested to supply
because
copies
of
to
who
the
this
learned
case has
council
come.
appearing for the different parties.
Because
uh,
All right.
it is a suo moto
Yes.
We
registered
understand
judicial.
now
Yeah,
that it is no more
registered by
suo
you.
moto. The amount of the clamor, we can understand it is no more suo moto.
Mr. Dole is there, what sumoto?
No, it is initiated
Regist-
by the
initiated by
registry
registered
at the instance of the
Item
Supreme.
66.
Honorat.
And
Yes,
Na-
yes, your lords, I'm obliged.
My lord,
My
in
senior
this-
has filed the affidavit which I have received
This
yesterday.
is a very important case. Your lordship may see, this is related to
That's
Konark
not the,
court.
Photograph.
my lord is saying,
I have filed-
my lord is reminding us.
Just, I have filed my affidavit. Your lordship has directed me to file a short affidavit, whether the plot in question is coming under CRS zone. And
ESJ.
yes, this one, sorry. And I have filed the affidavit of the concerned Tahsildar with the letter of the DFO, concerned district forest officer, that stating inter alia that it is not coming under that particular zone. So your lordship may keep it tomorrow.
Take it up, take it
I
up.
have received the copy, my lord. What?
You want to file any rejoinder?
Yes, my lord.
So that we'll keep a date.
All right. At
That
the
is what
request
is
of
my
such
prayer.
and such,
Some
Mr.
other-
Das, learned counsel appearing for the petitioner. Let the matter be listed on
Please.
30th of August,
As your lordship.
30th of August,
I've seen the
2023.
track.
Meanwhile, the petitioner may file the reply affidavit in response to the affidavit filed by the state.
My lord, in fact, the affidavit is only.
My lord, item 20,
I
my lord.
understand. Whatever they want to say, let them say.
My lord, item 20, my lord.
Godavaran
My lord,
decision.
I am on VC, item 20, my lord.
Item
May be
20.
listed.
Order is not been-
Item 20.
Well, just wait. We have passed the order in item 20. Just wait.
Tanani padigive. Ita ko kartari hoytile.
What is the date? Yeah, what is your prayer then? Item 20?
Take up
My
now.
lord, I don't know the case of death of a minor boy by electrician. So,
This,
Damages.
on 31st of August, again it will come.
my lord.
Eastern 31st of August. Huh?
445.
All right, we are rising now.